Hello, good morning, and welcome to Byju's Exam Prep. Yesterday, we initiated a discussion on Directive Principles of State Policy. Part 3, Part 4, Part 4, capital A. What do they do? Although they are separate units, separate parts of the Constitution, yet together they concretize, they give shape to the lofty goals, to the lofty ideals of liberty, equality, justice, these objectives which are mentioned in the preamble. Part 3, fundamental rights, basically are limitations on the powers of the state. We call them negative obligations. Directive principles of the state policy, these are positive obligations. Fundamental rights are for the promotion of political democracy. DPSPs are for the promotion of social and economic democracy. And fundamental duties basically have an educative value. The job is, the purpose is, the objective is to make Indians responsible citizens. Clear? We've discussed fundamental rights. Yesterday, we started with directive principles of state policy. And there we discussed that the primary objective of directive principles is to establish a welfare state, a state which exists for everybody, for weaker, marginalized sections of the society, those who have no means of livelihood, those who do not have sufficient food, nutritious food. It is for the upliftment of these sections of the society that our state exists. And we discussed that these directive principles are non justiciable. That means these are not enforceable in a court of law. That's characteristic number one under Article 37. But at the same time, these directive principles, it shall be the duty of the state to implement all these directive principles of the state policy, because these DPSPs are fundamental for the governance of the country. And then we discussed that when we look at all these DPSPs, we can identify these DPSPs and categorize them based on whether these are socialist principles, whether these are Gandhian principles or liberal intellectual principles. And I had given you an assignment. Did you check that? Did you manage to go through all these DPSPs to identify in which category do they belong to? Subhajit, yes. Deepika, yes. Harish, no. Why no? Okay. Then we looked at if the state wants to implement these DPSPs, but in the process, it violates fundamental rights. What is the relationship between the two? What will prevail, DPSP or fundamental rights? The initial position of the Supreme Court was that directive principles are inferior, fundamental rights are superior. But because of various amendments to the Constitution, 31 capital A, 31 capital B, 31 capital C, now we can see that the present existing condition is that there are two DPSPs, 39B and 39C. They have primacy over two fundamental rights. Which are these fundamental rights? Article 14 and 19. Clear? And then we jump to Uniform Civil Code. We looked at the Goan model of Uniform Civil Code. Then we looked at the Special Marriage Act and what are the problems with Special Marriage Act. And then we discussed that basically we have completed, implemented, given shape to almost all the directive principles of the state policy, barring Article 44, which talks about Uniform Civil Code. What are the arguments in favor of Uniform Civil Code? What are the arguments against Uniform Civil Code? And what is the solution then? If we can't implement UCC, then what is the solution? What is the alternative? That's also something we have discussed. But I told you right at the start why these DPSPs are not enforceable in a court of law. The reason behind that I will tell you slightly later, and now the time has come for me to explain why these DPSPs are not enforceable in a court of law. When the Constituent Assembly was debating the constitution, there was a debate on DPSPs. What was the debate? That make these DPSPs justiciable, enforceable in a court of law. Because what are these DPSPs? They are meant for promoting social and economic democracy. They affect everyday life of an individual. Nutritious food, enhancing the standard of living, equal pay for equal work. Workers should be involved in the management of the industries. Maternity relief should be provided. Claims of SCs and STs and government jobs should be recognized. All these DPSPs, they basically have day-to-day relevance in the lives of the people. And that is why they should be made justiciable. That was the demand by the majority of the members of the Constituent Assembly. The demand was that DPSPs are meant for promoting social and economic democracy, and it is necessary that these should be justiciable, enforceable in a court of law. But nevertheless, it was not made enforceable, non-justiciable. Why? Not because they are inferior to any other part of the Constitution, but because of two reasons. Why? Reason number one, the state needs time to implement DPSPs. Reason number two, the state needs resources to implement directive principles of the state policy. Time in the sense, imagine today is 26th of January 1950, when the Constitution was enacted. If your fundamental rights are violated today, your freedom of speech and expression is violated, your right to equality is violated, your right against discrimination is violated, what is the alternative? What is the remedy available to you? Knock the doors of the court. The court will protect, uphold your fundamental rights. But what if on this day, DPSP is not implemented? DPSP such as organizing village panchayats in all the villages in India, improving the standard of living of the society, minimizing the gulf between the rich and the poor. It is a long-term project. It cannot happen immediately because the state needs time to implement this. And if the state has to provide maternity relief, equal pay for equal work, right to work, education, all these important DPSPs, they need resources as well. But the country was not in a good financial stage when we got the independence. After Aurangzeb died, the contribution to the world trade was 27% from India. 27% of the world trade, or some would also say that 27% of the world GDP was the contributing of India. But then because of drain of wealth, because the British, when they came to India, they saw India as Sone ki chidiya, a golden sparrow. And then the wealth was drained from India, and because of which it became one of the poorest countries of the world when British left India and gave India independence. So we lacked financial backing, we lacked financial resources, so we could not have made these DPSPs justiciable. But whenever we will have time, whenever we get the resources, whenever we have the consensus, all these directive principles shall be implemented. That is what Dr. Ambedkar said. Dr. Ambedkar said these DPSPs, they do not have legal sanction. That means they are not enforceable in a court of law. You cannot approach the court asking the court to protect your DPSPs because these DPSPs are not enforceable in a court of law. So they do not have legal sanction. But Dr. Ambedkar said these DPSPs have political sanction. How? I will tell you now. Even if these DPSPs are not enforceable in a court of law, in the courts, in the judiciary of this country, not enforceable, nevertheless, they are enforceable in the court of the public. Every election which is conducted every 5 years in India, there are periodic elections in India. People will have the power to vote that government in which has implemented directive principles of the state policy. Because these DPSPs, as I told you, they have day-to-day relevance in the lives of the people. If the inflation is very high, which means the standard of living will come down of the people. If people are not given employment opportunities, which means right to work has reduced. If maternity relief is not given, that means members of the women community, they are being not given their due, not given their share. What people will do, people will vote that government out of power if it is not implementing these DPSPs. Because these DPSPs and their implementation directly affects the everyday life of the people of India. So Dr. Ambedkar said, forget about legal sanction. You can't go to the court for the enforcement of fundamental rights. But these DPSPs are implementable, enforceable in the court of the public. Any government which disregards these DPSPs, which does not improve the standard of living of the people, which does not give employment opportunities to the people, which does not give right to work to the people, that government will be voted out. So these DPSPs, they have political sanction. They are enforceable in the court of the public. Pandit Nehru went a step further. Pandit Nehru said these DPSPs act like a lighthouse, constantly reminding the government of its duty and the responsibility. What is that lighthouse? You're preparing for the civil services examination. And the most important thing for your preparation is the timetable, is the schedule. Daily targets, weekly targets, fortnightly targets, monthly targets that you have set out. And then you will look at this timetable which is pasted on your wall or which is there in your copy. And you will constantly look at this timetable. Have I completed these many topics from polity? Have I completed and understood the Hindu newspaper? Have I completed the answer writing session? If yes, today's job is done. So for the government, for the state, these DPSPs look like that timetable, that lighthouse, constantly reminding the government of its responsibility. The government will keep on looking at these DPSPs and check if we have implemented these DPSPs. If not, then our job is still not done. So it's like a lighthouse, constantly reminding the government of its role and responsibility. And Dr. Ambedkar said these DPSPs are like a blank check, but you can encash this check at the discretion of the bank. You have money in the bank, 1 crore rupees in the bank. This is your check. You can encash this money, provided the bank has the resources. All these DPSPs, they're basically meant for promoting social and economic democracy. These should be implemented. It shall be the duty of the state to implement these DPSPs. But if the state does not have resources, you will have to wait. If the state has resources, if the state has time, then you can claim these directive principles of the state policy because these are enforceable in the court of the public. That is the significance of directive principles of state policy. This chapter is over. Any questions? No, yes, maybe. Okay. Now let's look at Part 4, capital A of the Constitution, which deals with fundamental duties. And I've told you what is the purpose of fundamental duties. Basically, to make Indians responsible citizens. These fundamental duties were not originally part of the Constitution. These fundamental duties were added to the Constitution by 42nd Constitutional Amendment Act. The year was 1976. So Part 4, capital A was added to the Constitution in 1976 through 42nd Constitutional Amendment Act, which means fundamental duties were not originally part of the Constitution. They were added later through a constitutional amendment. Initially, there were 10 fundamental duties prescribed, but in the year 2002, because of 86th Constitutional Amendment Act, 11th fundamental duty was added. So right now, how many fundamental duties we have? We have 11 fundamental duties mentioned under Article 51 capital A of the Constitution, which deals with Part 4 capital A. What's the context? These duties are generally not found in the constitution of Western liberal countries. For example, if you look at the countries such as United States, if you look at the constitution of Canada, Australia, they have no place for duties. They exclusively, specifically focus on the rights of the citizens. So it's like state is giving everything. The state is not expecting anything in return. So in these Western liberal constitutions, their primary focus is on empowering the citizens, on providing them a set of rights. So that means state is giving more. But then in countries which are socialist countries, for example, India, for example, Japan, they also have a place for fundamental duties. They look at the concept in a form of give and take, a symbiotic relationship where the state has given you rights, although these rights are given by the constitution, but the state has to give you those rights, has to implement those rights for you. And in return, the state is expecting some duties towards you as well. So that symbiotic relationship is normally seen in the communist societies or socialist societies. When the constitution was enacted, there were some people who were critical of the constitution, particularly Mr. P.V. Kane, who writes in the History of Dharmashastras, Volume 5, that our constitution is blindly aping the Western constitutions, blindly following the Western constitutions. Western constitutions are focusing primarily on rights, but we are Indians. As Indians, we have duties. Duties towards our parents, duties towards our environment, duties towards our wildlife, duties towards the state, duties towards the teachers, duties towards the marginalized, weaker sections of the society. And it is this aspect of duties which has been neglected by the constitution. So Mr. P.V. Kane, who in later period was also awarded the Bharat Ratna, the highest civilian award in India, he was highly critical of the constitution on one ground, that our constitution is only focusing on rights and not on the duties that we may have as citizens towards fellow citizens, towards the state, towards the environment. And then the objective was to make citizens responsible, and that is why in 1976 the constitution was amended. Srimati Indira Gandhi was the prime minister. She was asked, Madam Gandhi, what is the need to add fundamental duties chapter to the constitution? She said people are more aware of their rights. You all claim rights. I have right to equality, I have right to freedom, I have religious freedom, I have right against exploitation. But people are not aware that they have duties towards the state as well, towards fellow human beings as well. So if they're aware of their rights, I want to make them aware of their duties as well. And that is the reason why constitution should be amended, so that a list of fundamental duties is prescribed for the citizens. Therefore, these fundamental duties, they have an educative role. And what is that educative role? Basically, they educate the people about their duties, their responsibilities towards the state, towards the fellow human beings, towards the environment, wildlife, and other sections of the society. A committee was set up known as Sardar Swaran Singh. Sardar Swaran Singh was the External Affairs Minister then. A committee was set up by the government headed by Sardar Swaran Singh. Sardar Swaran Singh was asked, please look at a list of fundamental duties that we can provide in the constitution for the citizens of India. Sardar Swaran Singh came up with a report. Some of these recommendations were accepted. Some of these recommendations were not accepted. And those recommendations which were accepted were then added to the constitution in the year 1976, when the constitution was amended for the 42nd time. And then 10 set of fundamental duties were provided. Later on, 11th fundamental duty was also provided. So in total, we have 11 fundamental duties. But now, you will have to memorize these fundamental duties. Sir, you said you don't have to memorize articles, but I also told you that there are some articles which you have to memorize, and I will tell you which are these articles. And today, Article 51 capital A, you will have to memorize. You will have to memorize all these 11 fundamental duties. Why? Because tomorrow there can be a question, and there have been questions. Which of the following are fundamental duties? So you have to be absolutely clear which of these are fundamental duties, because the wording of some of these fundamental duties closely mirror, they sound similar to some of the DPSPs. So you have to be absolutely clear which one is a DPSP, which one is a fundamental duty. Now you can't memorize all the DPSPs from Article 38 to 51. Then if you can't do that, then at least we can remember all the fundamental duties, and it is easy to remember. I'll tell you how. So if you remember all these fundamental duties, so at the time of the examination, you will be absolutely sure that these are fundamental duties, the others may be directive principles of the state policy. Now, how do you remember and memorize these fundamental duties? For that, there is an acronym. There's a formula. What's that formula? Let's suppose for a while you are preparing for the civil services examination. And once you clear this examination, you want to become an IAS, IPS, IRS, IFS officer. Let's assume that you want to become an IPS officer, Indian Police Service officer. You will be recruited as Assistant Commissioner of Police, or if it is a village or a rural area, initially on probation, then you will become a Superintendent of Police. Then after some promotion, you will become a Senior Superintendent of Police, SSP. But then you are corrupt. When you are corrupt, you're taking bribe, you're seeking bribe, you have amassed huge wealth because of this corruption. One fine morning, you're having breakfast, you're having coffee, there's a knock at your door. Who is that? We are from Anti-Corruption Unit. Okay, why are you here? We want to arrest you. Why? Because you have indulged in corruption. Don't tell me this. What's the proof that you have? They will show you a DVD where it is shown that you are taking bribe, you're seeking bribe. So they have a proof in the form of a DVD that you have indulged in corruption. What will you do? You will call Arnab Goswami. Mr. Goswami, please don't broadcast this news. Please don't scream at 9 o'clock in the evening that the nation wants to know why this SSP was arrested. Please don't do that. You will call other journalist friends. Please don't publish this story, please, please. This in corporate language we call PR, public relations. And ultimately what will happen? You will win. SSP 3, ACU 3, DVD 3, 9, this is 10, this is 11. These are 11 fundamental duties that are mentioned in the Constitution. SSP, ACU, DVD, PR, W. What are these deep fundamental duties? To strive towards excellence in all areas of human endeavor, to safeguard public property and to abjure violence, to protect and promote the rich heritage of our composite culture, to abide by the Constitution, respect its ideals, national flag and the national anthem, to cherish and follow the noble ideals which inspired our struggle for freedom, to uphold the unity, integrity, sovereignty of India, to develop scientific temper, spirit of humanism and reform, to value and protect and preserve the natural environment, forests, lakes, so on and so forth, to defend the country and render national service when called upon to do so. So all these fundamental duties you can memorize using this acronym. And now let's look at all these one by one. For example, to abide by the Constitution, respect the national flag and the national anthem. This is A. Second, C. To cherish and follow the noble ideals which inspired our national struggle for freedom. U. to uphold and protect the sovereignty, unity, and integrity of India. S, to strive towards excellence in all areas of individual and collective activity. Similarly, another S, to safeguard public property and to abjure violence. P, to promote harmony. No, this is to protect and improve natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. D, to defend the country and render national service when called upon to do so. V, to value and preserve the rich heritage of our composite culture. D, to develop scientific temper, humanism, and spirit of inquiry and reform. PR, to promote harmony and to renounce practices which are derogatory to the dignity of the woman. And this W was the last one added to the Constitution, 86 Constitutional Amendment Act 2002. Can you recall what also happened in 2002 because of 86th Amendment? What happened? Right to education was made a fundamental right. Article 21 capital A was added to the Constitution, which made it a fundamental right that all the children in the age group of 6 to 14, they have a fundamental right to primary education. And it is this fundamental duty, 86 Constitutional Amendment Act, the 11th fundamental duty, which is related to that education. So this fundamental duty imposes a duty on the parent, on the guardian, that for your ward or your child, you have to provide opportunities for their education. That means there is a duty on the parent, the guardian, that for your child, for your ward, you have to provide opportunities for education. That is the 11th fundamental duty, which was added in the year 2002. This is how a set of 11 fundamental duties can be memorized and remembered for the examination. Any questions as of now? Yes, no? Okay. This is I, this is basically J. Okay. Now let's look at some of the important points regarding these fundamental duties. Japan is the only other country, democratic country, which has a list of fundamental duties for their citizens. And we have borrowed these fundamental duties from the Constitution of USSR. USSR is not existing now. USSR was dismembered in the late 1980s and 90s. Why? Because USSR was a group of a federal state which consisted of Russia, Ukraine, Tajikistan, Uzbekistan, Kazakhstan. So all these important states, they were part of the Russian Federation, USSR. But USSR got split in 1989, 1990, 1991. That you will discuss in the world history. And we have borrowed these provisions of fundamental duties from the Constitution of USSR. But there are some international covenants, some international conventions, some international agreements. For example, International Universal Declaration of Human Rights, International Covenant on Civil and Political Rights. They also talk about duties. So if we have these international conventions, for example, Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, they talk about that the state should give rights to the people, dignity for the people, justice to the people, freedom of speech and expression to the people. But at the same time, it also talks about the duties that people will have towards their state. So although constitution of Western liberal democracies, they don't have a place for fundamental duty, but the international agreements that we have signed, they talk about fundamental duties. They talk about duties of the citizens. And which are these conventions? Universal Declaration of Human Rights, International Covenant on Civil and Political Rights. And this question was asked in the prelims examination. Which of the following include a list of duties for the people? Fundamental duties, yes, But International Covenant on Civil and Political Rights, yes. Universal Declaration of Human Rights as well. And these fundamental duties are exclusively available to citizens. They are not available to foreigners. Because why would a foreigner abide by your national flag or national anthem or uphold your unity and integrity of India? That is only for citizens. That's not for foreigners. And at the same time, no mandamus. What is mandamus? We discussed in Fundamental Rights chapter that mandamus can be issued against a public body if this public body has failed to discharge its duty and thereby violates fundamental rights. Which means if a public body is not doing its job, is not doing its duty, which it is supposed to do. For example, the police is mandated to protect you, and now the police is not protecting you. For example, there is a couple and they are belonging to different religions or they belong to different castes, and now their caste members or their community religious members, they are against this couple. We will kill you. Why did you get married to each other? Now what will this couple do? They need protection. They will approach the police. Police is saying, no, since this is an inter-religious marriage, we will not protect you. These leaders will kill us. Since this is an inter-caste marriage, we will not protect you. These leaders will kill us. Then what is the right that you have? Approach the Supreme Court. What the Supreme Court will do? Issue the writ of mandamus. We command police, you do your duty and give security to this couple. That means those rights that you have, the mandamus, can be issued against a public body for failing to discharge its duty. But these fundamental duties, they are not legal duties. That means all the fundamental duties are applicable to me, but Constitution does not enforce them. Constitution does not talk about what is the punishment for these people who violate fundamental duties. No, because these fundamental duties, they are not legal duties. They only have an educative role to play. That is why if I am violating a fundamental duty, you cannot approach the court and ask the court, my lord, can you please issue the writ of mandamus so that this duty which I am violating, which I am not following, you direct me, you command me that I should abide by that duty, I should perform that duty. No, that cannot happen. Why? Because these fundamental duties, they are not legal duties. Sir, if these are not legal duties, then why did the Supreme Court previously said whenever the movie is played in a theater, in a multiplex, first a national flag should be displayed, then all the people should stand up in a rapt attention and listen to the national anthem for 52, 53 seconds. And only then you can sit down and watch the movie. Because the Supreme Court said we want to implement fundamental duty. It is the duty of you to uphold, protect, preserve the Constitution, and at the same time respect the national flag and the national anthem. When this judgment was given by the court, it was heavily criticized. Why? Because that's not the job of the court to introduce, indoctrinate patriotism. Patriotism is something which cannot be forced. You are patriotic by design. You are patriotic since birth. We cannot force feed patriotism to you. We're all patriots. And if the Supreme Court is telling the people, you stand up, listen to the national anthem when the movie is to be played, and then sit down, why is it that when the Supreme Court hears a case, they don't start with national anthem? It should have been applicable to them as well. But that cannot happen in a society. But then how is it that the Supreme Court tried to implement this fundamental duty? It did not implement fundamental duty. It basically spoke about a law. And what is that law? Prevention of Insults to National Honor Act, 1971. What does that mean? Fundamental duties. Part 4, capital A of the Constitution. It was not originally part of the Constitution. It was added to the Constitution by 42nd Constitutional Amendment Act 1976 on the recommendations of Sardar Swaran Singh Committee. Initially, there were 10 fundamental duties. 11th fundamental duty was added in 2002. Clear? And we have borrowed these provisions from the Constitution of the USSR. Although Western liberal constitutions, they have no place for fundamental duties, but there are some international agreements, conventions, covenants, such as Universal Declaration of Human Rights, such as International Covenant on Civil and Political Rights, which speak of duties. But these fundamental duties are not legal duties. That means if you violate these fundamental duties, no action will be taken against you. Why? Because these only have educative role. Clear? Constitution has not prescribed any punishment for those who violate these fundamental duties. No. But then Parliament can make a law and enforce some of these fundamental duties. Parliament did that. How? Parliament enacted a law called Prevention of Insult to National Honor Act. That means you cannot split the Constitution. You cannot burn the Constitution. If you burn it, you are committing insult to our national honor. For example, in United States, they have an absolute freedom of speech and expression. When they protest, they can even burn their national flag. When they protest, they can even burn their constitution. They can even wear the national flag as part of their undergarments. But that cannot happen in India. Why? Because that would be insult to our national honor. That means although the law was passed before fundamental duties were made part of the Constitution, but what do this law basically try to do? Tries to implement fundamental duties. Similarly, you cannot go against the sovereignty and integrity of India, because if you do, you can be arrested as well. You can be arrested under Indian Penal Code. You can be arrested under sedition as well. You can be arrested under Unlawful Activities Prevention Act, UAPA. You can be arrested under National Security Act. But sir, isn't it conflicting? On one hand, you're saying fundamental duties, they're not legal duties. That means even if you violate these fundamental duties, no action will be taken against you. That's a correct position, yes. But then there can be a law passed by the Parliament. And if you violate that law, for that there will be a punishment for you. And what is that law? If you violate UAPA, you can be arrested. If you violate Prevention of Insults to National Honor Act, you can be arrested. There is Wildlife Protection Act. If you kill a tiger, for example, which is under Schedule 1 of the Wildlife Act, you will be arrested. You will be sentenced to a jail term. So when we say there is a fundamental duty which talks about to protect, improve natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. If you pollute a river, you can be arrested under the Pollution Act. If you kill a wildlife animal, you can be arrested under the Wildlife Protection Act. That means you are arrested not because you have violated fundamental duty. You are arrested because you have violated a law passed by the Parliament. That's the difference between the two. Per se, as a group, these fundamental duties, they are not legal duties. So even if you violate them, no action will be taken. But then there are some laws which are passed by the Parliament, which try to implement these fundamental duties, which try to make these fundamental duties as legal duties. If you do that, if you violate those laws, then you can be arrested. And that is why there are some people who criticize fundamental duties. They say, what rubbish is this? I said, what is so rubbish about this? Real fundamental duties are not mentioned. Real duties that we should have as citizens, they are not mentioned. What? Duty to vote in the elections. Although we have right to vote as a constitutional right, but what is happening in India? People in villages, people in far off areas, people in rural areas, they come out in large numbers and exercise their right to vote. But what about people living in the cities? What about the people of Mumbai? Even when there was a massive terror attack launched from Pakistan, 2611 attacks in Mumbai, then candlelight marches were carried out by the people who are residing in Mumbai. And people thought that at least now this city, which is never sleeping, but it has now woken up to its rights. Now maybe they will participate in democracy in great numbers. 2009 election was conducted, only 50% turned out to vote. Why don't we say it is your duty to vote in the elections? Duty to vote in the elections is not a fundamental duty. We evade taxes. 2 to 2.5% of the people in India pay income tax. Duty to pay tax is not a fundamental duty. Look at the way our population is growing. We have, or we will soon surpass China as the world's populous country. Unofficially we have, officially we will do very soon. Family planning is not a fundamental duty. But what is fundamental duty? There are some vague ideas. Vague ideas such as to cherish and follow the noble ideals which inspired our national struggle for freedom. Which are these noble ideals? You speak to different people, they will tell you different story about India's independence. Why India got independence? On 15th of August 1947, it is because of Mahatma Gandhi. Okay. You ask someone else? No, it is because of the communists. It is because of the mutiny of the Navy. It is because of the launch of strong popular uprising by the communists against the British government. That's why we got independence. Others will say, no, it is because of the RSS. It is because of Veer Savarkar that we got independence. Otherwise, Nehru and Patel would have sold this country. So there are different versions. As many mouth, as many versions of India's history, as many versions of those ideals which inspired our struggle for freedom. So what ideal we have to cherish and follow? We don't know. This idea is very vague. And something else. To develop scientific temper, humanism, spirit of inquiry and reform. Scientific temper. What is science? Science is basically objective. What is science? Science will come up with a hypothesis that basically what will happen? This is a green leaf, chloroplast, chlorophyll, mesophilic region. Because of sunlight, sunlight will act as a catalyst. So we assume that because of these reactions, glucose, sucrose, photosynthesis takes place. So first you give a hypothesis. Then you conduct various experiments to prove your hypothesis. So science is all about objectivity. What is objectivity? You look at some data and then you come to a conclusion. Clear? When you look at this photosynthesis, you know that only green leaves or green plants, they manufacture their own food. That means it's all objective. But what we are seeing right now is completely different. Valentine's Day should be celebrated as the cow hug day. Is there science involved there? With no offense to any religious community whatsoever, but let's look at objectivity, let's look at science. One member of the government said that plastic surgery was carried out in ancient India because Lord Ganesha is a great example of plastic surgery. Whether true or not, I don't know. But what do activists say? What do writers say? What do those who follow the constitution say? They say this is violation of scientific temper. How can you say that plastic surgery, which emerged later, was being carried out in the ancient India and Lord Ganesha is an example of plastic surgery? I'm not saying this. There are people who say this. So lynch them if they are violating your sensibilities. But the point is, there are people who criticize fundamental duties, saying, number one, real duties are not mentioned in the fundamental duties chapter. Duty to pay tax, duty to vote in the elections, duty to and go about family planning programs. But then some vague ideals. ideals which shaped our struggle for freedom. That is a fundamental duty. Which ideal that is, we don't know. Composite culture. Where is composite culture? To preserve, value and preserve the rich heritage of our composite culture. What is that culture? Is it the Dravidian culture, the Tamil culture? Is it the North Indian culture? What sort of culture should we value, preserve, protect, which is part of our composite culture? We don't know, because India is unique, India is diverse. What sort of culture should be preserved and protected? So there are some vague ideals which are mentioned in fundamental duties, but the real fundamental duties are absent. That is why some people criticize fundamental duties. Facts related to fundamental duties, memorizing all these 11 fundamental duties, that's relevant for your prelims. And for your mains examination, you may be asked to criticize or write an argument in favor of these fundamental duties. And that completes our discussion on fundamental duties. Let me know if you have anything to ask. Point J. J is what? To strive towards excellence in all areas of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement. Strive towards excellence. Sir, but Amit Shah says we will implement UCC in whole India. So what's wrong with that? It's part of the constitution, should be implemented. Okay. Now let's look at amendment of the constitution, the doctrine of basic structure. What is that doctrine? First, we need to understand what is an amendment. Add something to the constitution is amendment. Remove something from the constitution is an amendment. Add an article, add a schedule, add a part, remove an article, remove a schedule, remove a part, add one line, remove one line, add even a full stop. That is an amendment. But what is the need to amend the constitution? Pandit Nehru said, what is a constitution after all? Something that we have discussed in the first class. Constitution is the document of people's faith and aspirations. But what are the aspirations of the people of India in 1950? Those may not be the aspirations of the people of India in 2023. And clearly, those will not be the aspirations of the people of India in 2053. So aspirations keep on changing. Expectations keep on changing. So if the country is in 2023 right now, this document, which is basically a document of people's faith and aspirations, which is basically the constitution, this constitution should reflect the sensibilities, aspirations of the people of India right now. That is why there is a need to amend the constitution. If the constitution cannot be amended, if there was no provision to amend the constitution, then this constitution would be like a religious textbook, which you cannot change, which you cannot alter, which you cannot modify. That's what Pandit Nehru said. Constitution should not be so rigid that it cannot be adapted to the changing needs of national development and strength. If aspirations of the people change, if the idea of the people change, if the expectations of the people change, this constitution should also change. Any popular demand should be capable of realization. What is the popular demand? The demand of the people is right to safe drinking water should be a fundamental right. There should be a provision to change the constitution and make it a fundamental right. The demand of the people was right to education should become a fundamental right. It became possible because we had the provision to amend the constitution. The demand of the people was that we should enact Land Reforms Act. We should reform the land in India. That was possible because constitution can be amended. So what is an amendment? We know. What is the need to amend the constitution? Because this constitution, which is the document of people's faith and aspirations, any popular demand that people may have should be capable of realization. That means this constitution, which is basically a beautiful document, which basically reflects the sensibilities, the aspirations of the people, this document should also be allowed to change, modify, adapt. Dr. Ambedkar went a step further. Dr. Ambedkar said it is possible that some of you may not be happy about this constitution. He was speaking in the Constituent Assembly when the final constitution was almost ready. He said, now this constitution that we have created, we have established, I am 100% sure that it will result in a good India. But if it is not able to meet its objective, I will be the first person to burn it. And there may be people who may not be happy with this constitution. And it is possible. You cannot satisfy 100% of the population. Mr. Modi is doing good, but not everybody is happy. Some people will be critical. Rahul Gandhi may be doing good, but not all people are happy. Some are critics as well. So you can't satisfy 100% population ever. Not possible. And Dr. Ambedkar said, if you are dissatisfied with this constitution, don't worry. Do one thing. Get 2/3 majority and change the constitution. Dr. Ambedkar was asked, can you clarify? He said, look at this parliament. This parliament consists of people elected by the people of India. That too on the basis of universal adult franchise. Everybody who is an adult, regardless of your religion, race, caste, sex, property, educational qualification, doesn't matter, you have the right to vote. And all these adults, because right to vote should be given to an adult, so that an adult can make up a mind whether I should vote for A or B, because a child does not have that maturity to decide who is good for the nation, who is not. Adults can have that maturity. All the adults, regardless of your religion, race, caste, sex, place of birth, educational qualification, property rights, doesn't matter, you have the right to vote. And it is all the people of this country who have voted in the elections and elected members to the parliament. And now you elected members of the parliament. If you can get 2/3 majority in parliament, change the constitution. Because you are elected by the people. So if 2/3 of the people in parliament, they want to change the constitution, that means 2/3 of the people of this country, they want the constitution to change. And that is what Pandit Nehru said, any popular demand should be capable of realization. But Dr. Ambedkar said, if you are dissatisfied with the constitution, but you cannot get 2/3 majority, then we can safely say, only you are dissatisfied with the constitution. Your dissatisfaction cannot be shared, cannot be deemed to have been shared by the larger public. You may be dissatisfied, but you are in a minority. Because the majority, 2/3 of them, they don't want the constitution to change. So what is an amendment? Make any change to the constitution. Change is not only you want to add something. Even if you want to remove something, even if you want to delete something, that's an amendment. Clear? But what is the need to amend? Because constitution is the reflection, is the document of people's faith and aspirations. Aspirations keep on changing. Any popular demand should be capable of realization, which means change the constitution. Dr. Ambedkar said, you may not be satisfied with the constitution. I agree. I can't satisfy anybody and everybody. If you're dissatisfied, get 2/3 majority in the parliament and change it. If you cannot get 2/3 majority, that means I can assume only you are dissatisfied or a small minority is dissatisfied. Your dissatisfaction cannot be deemed to have been shared by the larger public. Larger public do not share your dissatisfaction. You are dissatisfied. Majority is not. Get 2/3 majority and change the constitution. Then something happened. On 24th April 1973. 1973, was an eventful year in India, in the history of independent India. 1973, Bollywood gave us its first chocolate hero. Rishi Kapoor made his debut in the movie Bobby. 1973 was the year when efforts were made to save India's national animal. Project Tiger was launched by the government in 1973. 1973 was the year when Mysore was renamed as Karnataka. 1973 was the year, particularly 24th April 1973, when Sachin Ramesh Tendulkar was born, the man who saved India's cricket. But for our examination, 24th April 1973 is an eventful date because on this date, Keshavananda Bharti case was decided by the court. And it was a landmark case in the history of independent India. This case was heard by 13 judges, which is highest till date. This judgment was in close to 702, 703 pages. This case was heard for the longest time. This case was heard for 68 days. Sir, how can you say this case was heard for 68 days and it is longest? Because there are cases which are pending for decades, 20 years, 15 years. Those cases are pending because we don't hear them. They have not yet come up for hearing. But once the case has come up for hearing, then from the date the hearing took place, the first date, how many days of hearing did it take to end this case? In how many cases, in how many days this case was heard by the court? The highest number of days that Supreme Court heard a particular case, that was Keshavananda Bharti. For 68 days it was heard. Attorney General, who was representing the government then, when he tried to convince the judiciary of something, which I will tell you what, he made a comparison of more than 68 countries of the world. He compared the constitutions of more than 68 countries of the world. And there was one single point-blank question that Supreme Court had to answer, that these 13 judges of the Supreme Court had to answer. And what was that question? Is the power of Parliament supreme? That it can amend any provision of the Constitution. This was the single most important question that the court had to answer. Is the power of Parliament supreme that it can amend any provision of the Constitution? Why? Because when you look at the text of the Constitution, nowhere was there a limitation on the power of the Parliament. Nowhere. The only limitation that we saw in Article 13 was you cannot pass an ordinary law and amend the fundamental rights, delete the fundamental rights, modify the fundamental rights. Apart from that, there was no restriction whatsoever. Dr. B.R. Ambedkar said, get 2/3 majority in Parliament, change the Constitution. Pandit Nehru said, any popular demand should be capable of realization. Statements of Pandit Nehru, statements of Dr. Ambedkar, the text of the Constitution, nowhere was it mentioned that there are these limitations, restrictions on the powers of the Parliament. That you can change this, but you can't touch those provisions. Nowhere was there any restriction. And now it was for this 13-judge bench of the Supreme Court to answer, is the power of Parliament supreme that it can amend any provision of the Constitution? The Supreme Court said, yes, there is a limitation. Don't touch the basic structure. Apart from that, you can touch any provision of the Constitution. But what is that basic structure? How did we reach there? For that, we have to look at the history. History, first, Shankari Prasad Deo versus Union of India, 1951. Zamindari Abolition Act, Land Reforms Act, Patna High Court said unconstitutional. Why? Because you are giving shape to DPSP, but you are violating fundamental rights. DPSPs are inferior, fundamental rights are superior. Madras government's order that we will provide reservation in government engineering and medical colleges for those belonging to SC and ST community. Why? Because we are implementing DPSP. Matter went to the court. Champak Dorerajan, Supreme Court said Madras government order is unconstitutional because DPSPs are inferior, fundamental rights are superior. How did the parliament respond? Parliament amended the constitution. How? Using Article 368. Using Article 368, Parliament amended the constitution. What is Article 368? For example, there is a burner, gas stove, for example. If it does not light on itself, for example, if you need a, what's that called? A lighter to switch on, turn on the gas. That means you use the lighter, give the spark will burn the gas stove, and ultimately you can cook the food. That means you are using that charger or you are using that device to ignite the fire. Similarly, what provision is used to amend the constitution? That is Article 368. And Parliament used Article 368 because Article 368 talks about various provisions that the bill should be introduced in Parliament, then this bill should be passed by special majority. All those things are mentioned in Article 368. So using Article 368, what Parliament did, it amended the constitution. What was amended? Article 31A, 31B was added to the constitution. Basically, 9th schedule of the constitution was added. Any law which is placed in 9th schedule, there is no judicial review. Who said this? Parliament. How? By amending the constitution. How? By taking the route of Article 368. Matter went to the court. Shankari Prasad Deo versus Union of India. My lord, I have a case. I said, what case? Constitution has been amended by the Parliament using Article 368. But Article 13 Clause 2, it basically says state cannot pass any law. And through this law, it cannot delete a fundamental right. It cannot even modify a fundamental right. But my lord, what has happened? Parliament has used Article 368, which is basically the law passed by the Parliament. And through this law, it has modified fundamental rights. Please declare this as unconstitutional. The Supreme Court asked the government, come here. What are you doing? Sir, we have amended the fundamental rights. But the petitioner says you can't do that because Article 13 Clause 2 imposes a limitation on you. You cannot pass any law through which you can delete, modify, abridge fundamental rights. I said, yes, that is true. He's absolutely right. But he is misleading you. I said, why? He said, because there is Article 13 Clause 3. What does it say? It gives us the explanation of what is a law. What is that explanation? Sir, it says through an ordinance, through a rule, through a regulation, through a notification, through a bylaw, through a custom, through a usage, through these things, through these laws, you cannot delete, modify, abridge a fundamental right. But we can always pass a Constitutional Amendment Act under Article 368. Because Parliament through an ordinary law, government through a rule, through a notification, President through an ordinance cannot delete, modify, abridge fundamental right. But law is different. Constitutional Amendment Act is different. What we have done, we have passed a Constitutional Amendment Act under Article 368 and we have modified fundamental rights. Because law is different, Constitutional Amendment Act is different. Supreme Court said, okay, I think you have convinced us. It's completely fine. Article 31A, constitutional. Article 31 capital B, constitutional. 9th schedule of the constitution, constitutional. What does it basically mean? Parliament can do anything using Article 368. Parliament can delete a fundamental right, modify a fundamental right, maybe change the whole system of fundamental rights, but using Article 368. Who said this? Supreme Court in Shankari Prasad Deo versus Union of India, 1951. Fast forward, we reached Golaknath case, 1967. This time, 11 judges of the Supreme Court were hearing a matter. What was the context of this case? Don't go into that context. Just understand what the court has said. 11 judges of the Supreme Court said, no, you can't do that. Said what? You can't use Article 368 to delete, modify, abridge fundamental rights. Sir, how can you say that? Because Article 13 Clause 2 says, the state cannot pass any law. And through this law, you cannot delete, modify, abridge fundamental right. Sir, but we have said previously, and you have also agreed in 1951 Shankari Prasad case, that law is different and Constitutional Amendment Act is different. Law, ordinary law passed by Parliament, ordinance issued by the President, rule issued by the executive. Through these things, we cannot delete, modify, abridge fundamental right. But through a Constitutional Amendment Act passed under Article 368, we can. Because law is different, Constitutional Amendment Act is different. Through law, we cannot, but through Constitutional Amendment Act, we can. Said, no, you can't do that. Sir, why? Because Constitution says under Article 13, Clause 2, Parliament cannot, state cannot pass any law. When we say any law, that means any law includes a Constitutional Amendment Act. That means through any law also, even if it's a Constitutional Amendment Act, you cannot delete, you cannot modify, you cannot abridge fundamental rights. So fundamental rights are beyond your amendatory powers. Don't dare touch them. But sir, Article 368 gives us the power, gives Parliament the power to amend the Constitution, right? Said, no. Who told you Article 368 gives the power to the Parliament to amend the Constitution? Sir, Article 368 itself. No, please read it again. How, sir? Article 368 talks about procedure for amendment. If you look at the title of Article 368, if you look at the headline of Article 368, Article 368 headline is procedure for amending the Constitution. Just like for Part 1 of the Constitution, you have Union and its territory. Part 2, citizenship. Part 3, fundamental rights. Part 4, directive principles. Part 4, capital A, fundamental duties. Similarly, Article 368 talks about procedure for amendment. It does not give you the power to amend the Constitution. But sir, if procedure is mentioned, doesn't it mean naturally that we have the power to amend the Constitution using the procedure mentioned under Article 368? Said, no, that you can't do. Sir, then what should we do? I don't know. Maybe set up a new Constituent Assembly. Sir, what? Set up a new Constituent Assembly. Sir, why? Because Parliament does not have amendatory powers. You are electing people of India. People of India are electing you, representatives, not to amend the Constitution, to make ordinary laws, to run the government on a day-to-day basis. You don't have the power to amend the Constitution. Sir, then what do? Set up a new Constituent Assembly. And that new Constituent Assembly will use the procedure mentioned under Article 368 to amend the Constitution. But this Parliament cannot. You have to set up a new Constituent Assembly if you want to make any changes to the Constitution. Constitution cannot be amended by using Article 368. Article 368 only talks about a procedure, and that procedure should be followed by a Constituent Assembly. Sir, but isn't it conflicting? Previously you said something, now you are saying something, and that's how it should be. Interpretations change. At that time, our interpretation was different. Now our interpretation is different. So if you want to know, long story short, don't dare touch fundamental rights, because that's not your power. Because if Article 13 Clause 2 says state cannot pass any law means any law, including a constitutional amendment act. Don't you dare touch fundamental rights. And if you want to touch fundamental rights, maybe set up a constituent assembly. And that constituent assembly can use the procedure mentioned under Article 368 to modify it, change it, alter it. But you cannot. Something else happened then. Indira Gandhi was the prime minister after the Golaknath judgment, and she got the parliament, and lots of changes were made to the constitution. What was the change? Change number one was in 1971. First, we have to take into account the president, because tomorrow president may create some problems. 1971 constitution was amended, saying that whenever a constitution amendment bill is passed by both houses of the parliament, sent to the president will have no other option, only one option: sign this bill. That was change number one. Because we will discuss in president's chapter that president also has some veto power. President may sign a bill, may not sign a bill, may return a bill, may not act on this bill. But in this case, the first thing that parliament did, Indira Gandhi was the prime minister. Parliament said, let's amend the constitution under Article 368. What we will do, whenever a constitutional amendment bill is passed by both houses of the parliament and it is sent to the president for signature, he cannot refuse. He cannot send the bill back. He cannot sit on this bill. All he has to do, only one option: sign it. Sign, otherwise I'll kill you. Sign it. Okay, that was change number one. Change number two. Madam Gandhi, do you know what Golaknath judgment has said? What? They're saying that law and Constitutional Amendment Act, it is same. That means through law, you cannot change, you cannot modify, you cannot abridge of fundamental rights. Indira Gandhi sought help from legal experts, saying, what should we do? Madam, you amend the constitution, we are with you. No, but what should I amend? Where should I mention something? Madam, add Article 13, Clause 4. Law and Constitutional Amendment Act is different. Using Article 368, you can delete, modify, abridge fundamental rights. But Madam Gandhi, Parliament does not have the power to amend the constitution. That's what Golaknath case said. Because Article 368 talks about procedure for amendment. It does not talk about power of the parliament to amend the constitution. Okay, so what do? Madam, let's amend the constitution again. What should we amend? Let's amend Article 368. Let's change the title of Article 368. So if the title of the Article 368 is procedure for amendment, we will change this title to power of the parliament to amend the constitution and the procedure therefore. That's what the Supreme Court said, no? Supreme Court said Article 368 only talks about procedure for amendment. It does not confer power on the parliament to amend the constitution. Let's change the title as well. Power of the parliament to amend the constitution and the procedure therefore. Madam, what if it is challenged in the court? We will defend it then. But as of now, let's make changes to the constitution. Okay. Ma'am, how many changes? Number one, we will say, whenever a constitutional amendment bill is passed by the parliament, sent to the president, he has no other option but to sign. Sure, ma'am. Then what do? We will add Article 13, Clause 4. We will say nothing in this article shall apply to an amendment to the constitution made under Article 368. What is in this article? That state cannot pass any law to delete, modify, abridge a fundamental right. This does not apply. This restriction does not apply. This limitation does not apply if the parliament is using Article 368 to amend the constitution. Madam, we should make similar change to Article 368 as well. Said, yes, we will make changes to Clause 3 of Article 368 itself, which provides nothing in this Article 13 shall apply to an amendment made under Article 368. Madam, what? We will change both 13 as well as 368. In 13, what is mentioned? that state cannot pass any law to delete, modify, abridge a fundamental right. So we have to create an exception that Constitutional Amendment Act is not a law. Constitutional Amendment Act is different. Through Constitutional Amendment Act, you can delete, modify, abridge a fundamental right. That we will mention in Article 13. And in Article 368, which talks about procedure for amendment, we will say that Article 13 is not a limitation on us. Because Article 13 says you cannot pass any law. That law is different. Constitutional Amendment Act is different. And what did the Supreme Court say? We don't have the power to amend the Constitution. How did they arrive at this conclusion? They looked at Article 368 title. Let's change the title and say it is not procedure for amendment. It is power of the Parliament to amend the Constitution and the procedure therefore. Okay, ma'am. Other changes were made. Article 31 capital C was added. 25th Constitutional Amendment Act 1971. What it basically did, it gave primacy to two directive principles of state policy, 39B and 39C, over three fundamental rights, 14, 19, and 31. That means further changes were made. Another change was made. Privy purse was abolished. 26th Constitutional Amendment Act. Privy purses abolished. But something substantial happened in Kerala. What happened in Kerala? Keshavananda Bharti. He was a young head of the Mutt in Kasaragod district in Kerala. He was heading a religious body. And ultimately what happened? This religious body also had some sugar firms as well, some sugar mills as well. And Kerala legislature had passed a law called Kerala Land Reforms Act, under which the Kerala government could have snatched the land of any private player, even if this land belongs to a religious body. What did Kerala do? Kerala started land reforms and said we can take over the management of a company, we can acquire the land and property of an individual, private individual, even if this land, even if this property, even if this company belongs to a religious group as well. Kerala government was told, but somebody would challenge this law, so you have to be very careful. Said, don't worry, I've spoken with the central government. About what? We will place this Kerala Land Reforms Act in the 9th schedule. Okay, then what will happen because of that? Any law which is placed in 9th schedule, there won't be any judicial review. And because of this 29th Amendment Act 1972, the Kerala Land Reforms Act was placed in 9th schedule of the Constitution. Basically, major changes were made to the Constitution without restriction, without limitation. That means if this unlimited power is given to the Parliament, it can do anything. It can do anything using Article 368. Is this power of the Parliament supreme? Then Parliament will become sovereign to do anything that it wishes to do, anything that it wants to do. Is the power of Parliament supreme that it can amend any provision of the Constitution? Just like they have done. Changed Article 13, changed Article 368, changed Article 31, added 9th schedule, 31A, 31B, 31C, Article 15 changed, Article 16 changed. So many changes. Is there any restriction, any limitation on the powers of the Parliament to amend the Constitution? And in Kerala Land Reforms Act, the victim was Keshavananda Bharti, a young 21, 22-year-old young head of a mutt of a religious institution in Kasaragod district in Kerala. His property, his sugar mills, his land was also snatched by Kerala government. And this time, Nani Palkhiwala entered into the picture. Nani Palkhiwala had defeated Indira Gandhi or the central government 3 times previously. In Bank Nationalization Act, in Privy Purses, in other case as well. And now Nani Palkhiwala, somebody is approaching Nani Palkhiwala. He was in US. Can you please come and assist Keshavananda Bharti? Said, what has happened? their land, their property has been snatched by the Kerala government and the law is placed in 9th schedule. Said, okay, I'll come. I'll take another shot at the Supreme Court and we'll file a case. But Keshavananda Bharti and Nani Palkhiwala never met. This is perhaps the only case in the world where the lawyer is not meeting the client. Keshavananda Bharti, in his own self, a religious figure, a spiritual figure, his other people are coordinating, his other managers are coordinating with Nani Palkhiwala, and Nani Palkhiwala convinced them that don't file the case under Article 14, 19, and 31. No. Said, why? Because 9th schedule is a problem. Because Constitution has been amended in such a manner that even if you violate a law under Article 14, 19, 31, but if you're trying to give implementation to directive principle, no action will be taken by the judiciary. So we'll have to take a different route. So what is that different rule? You're the lawyer, you tell us. We will file this petition under Article 26. Sir, what is Article 26? Fundamental right belonging to every religious denomination. You have the fundamental right to establish, manage, and administer religious institutions. Whether this religious institution is for religious purposes or it is for charitable purpose. Keshavananda Bharti, you have an institution. And that institution is for religious purpose as well? Yes. But the sugar mills that you have, they are for charity purpose. So you don't pocket your profit. You basically get the money, get the revenue, get the profit, and you use it for charity for your own community. If this land is snatched from you, if this property is snatched from you, if this sugar mill is snatched from you, then your Article 26 is getting violated. Because how can you administer your institution without money? How can you provide, impart your religion and do charity if you do not have access to your property? Your Article 26 has been snatched. Matter went to the Supreme Court. And this case came to be known as Keshavananda Bharti versus State of Kerala. Because the case was filed by Keshavananda Bharti, but against what? Against the state of Kerala. Why? Because the Kerala government implemented Kerala Land Reforms Act. Nani Palkhiwala approached the Supreme Court. Supreme Court was told, we challenge the introduction of Kerala Land Reforms Act in 9th schedule. Why? Because it violates Article 26 of my client. Okay. As soon as people saw that Nani Palkhiwala has approached the court, others also approached the court. Mother of Scindia approached the court. My lord, my rights have been violated. I was a prince. My privy purse has been abolished. Said, come here. Others approached the court. Sir, Article 31 capital C. It disturbs the balance between fundamental rights and directive principles. Parliament has given primacy to directive principles, violating fundamental rights. Please help us. You are the guardian, protector of our fundamental rights. Said, come before us. And many cases were filed. When all these cases were filed, Supreme Court realized that all these different cases raise one question, one common question, one single question, one simple question. Is the power of Parliament supreme that it can amend any provision of the Constitution? Is there any restriction on the power of the Parliament that you cannot do this, you can do that? Supreme Court said, let's club all these cases together because all these cases raise common question. And all these cases were clubbed together and the case name became Keshavananda Bharti versus State of Kerala. Why? Because he was the first one to approach the court. And then Keshavananda Bharti case, it was heard for 68 days, 702 pages judgment. 13 judges were hearing this case. And Nani Palkhiwala started off with something interesting. And he talked about implied restriction. What is that implied restriction? Nani Palkhiwala approached the court and said, there is no mention of any restriction in the constitution on the powers of the parliament. I agree. There is no restriction, there is no limitation. Nowhere in the constitution does the constitution talk about any restriction on the powers of the parliament. There is no restriction. There can be restriction on fundamental rights. For example, you cannot delete, modify a fundamental right, but through an ordinary law. Through a constitutional amendment act, you may agree, you may disagree, but through a constitutional amendment act, parliament can do anything. That means using article 368, parliament can do anything. Is it mentioned anywhere in the constitution that you can use article 368, Mr. Parliament or Miss Parliament or dear Parliament, but you cannot touch these features? There is no restriction whatsoever. But my lord, there is an implied restriction. The Supreme Court asked, what do you mean by implied restriction? Nani Palkhiwala said, number one, we were a British colony, weren't we? Yes. Now we have gained independence. Have we? Yes. Now we have a democratically elected government. Do we have? Yes. Can this democratically elected government tomorrow use Article 368 in the parliament and give this country back to the British Empire? Would you allow that? So no, that can't be allowed because we have got independence. Now, forget about that can't be allowed or that can be allowed. Tell me, can this government give the nation back to the British Empire? No. But how can you say that? Is there any limitation on the power of the parliament to amend the constitution? There is no. But there is implied restriction. That means implication is that there are some things that you can't change. Even if you don't agree, you don't understand, I'll give you one more example. Constitution has given us a list of fundamental rights. And the most important of all fundamental rights is Article 21, right to life and personal liberty. Can Parliament use Article 368 and delete Article 21 saying a right to life is not a fundamental right? No, right to life is important right. How can Parliament snatch this? Forget about whether they can or they cannot. Can they snatch? But ideally, no. But is it mentioned anywhere in the Constitution that right to life cannot be snatched? Is there any restriction on the power of the Parliament to use and not use Article 368? No, there is no explicit restriction, but there is an implied restriction. Implied restriction in the sense, there are some things, even if they're not mentioned, but there are some things that you can't do. You can't gift your country back to the British Empire. You can't delete Article 21. Or forget about this. Can you give this country back to the Mughals? Or forget about this. Every 5 years, there are elections. Are there elections? Yes. What stops the parliament from using Article 368 and say from now onwards, the election will never be conducted? Can it happen? No, ideally it should not happen. But how can you say it should not happen? Because there is no restriction on the powers of the parliament to use Article 368. What stops a government which has the majority in the parliament from saying from now onwards there will be no elections, or from now onwards there will be elections after every 15 years? What stops this government from using Article 368? That means implicit in the reasoning given by the thundering Nani Palkhiwala was that there are some implied restrictions on the powers of the parliament. Parliament cannot do anything that it wishes to do. There is a restriction. And 7 judges of the Supreme Court, there were 7 judges who gave the majority verdict. 6 judges disagreed, dissented by the majority, but by the majority of 7-6. The Supreme Court said that there is something called basic structure. Parliament has the power to amend any provision of the Constitution, but it cannot violate basic structure. What is that basic structure? Supreme Court did not elaborate. Supreme Court did not lay down a permanent basic structure. Supreme Court left it for further interpretations. Future interpretations. Let the future benches of the Supreme Court add something to this basic structure. So we will not have a rigid definition of only this is part of the basic structure. We will leave it to the future judges. You add more features to this part of the basic structure, which means Parliament can do anything except touch the basic structure. But basic structure is something which was said by the Supreme Court judge, Justice Mudolkar. Five, 6 years before 1973. That means 5, 6 years before 1973, Justice Mudolkar of the Supreme Court said that there is something called basic structure, which the Parliament cannot change, Parliament cannot modify. And Justice Mudolkar borrowed it from the Pakistani Supreme Court. The then Chief Justice of Pakistani Supreme Court was Justice Cornelius. Justice Cornelius had said that there are some fundamental features of the Constitution which Parliament cannot change, Parliament cannot alter. Same feature, fundamental feature, was borrowed by Justice Mudolkar, and Justice Mudolkar said that there is something called basic structure. And then 8 years later, in 1973, in Keshavananda Bharti case, by the majority of 7:6, the Supreme Court said that there is something called basic structure. Parliament can use Article 368, change, modify any provision of the Constitution, but don't you dare touch basic structure. And what is that basic structure? Judicial review is part of the basic structure. Rule of law is part of the basic structure. Parliamentary democracy is part of the basic structure. Free and fair elections are part of the basic structure. Secularism is part of the basic structure. Article 21 is part of the basic structure. Article 32 is part of the basic structure. Independence of judiciary is part of the basic structure. That means the Supreme Court in 1973 did not lay down a permanent list of what is a basic structure, what constitutes a basic structure. This list keeps on adding. So what is basic structure? That's for the Supreme Court to decide. So Supreme Court is the final interpreter of what constitutes basic structure. And it will be surprising for you to know that Keshavananda Bharti lost his case. He lost his case, but Indian democracy won. It was upheld that yes, Kerala Land Reforms Act, it can take away the property, the land of individuals, even if it belongs to a religious institution. That is the right available to the Kerala government. You can do that. Keshavananda Bharti himself lost this case. But through this case, Indian democracy won. How? Let's explain. When we look at this doctrine of basic structure, there are those who criticize it, and there are those who favor this judgment or favor this doctrine of basic structure. The current Vice President of India, Mr. Dhankar, spoke in the Rajya Sabha and said, what are you doing? Your powers have been curtailed by unelected judiciary. There is a limitation imposed on you. You cannot delete, modify, abridge basic structure. This is not mentioned anywhere in the Constitution. This you won't see anywhere in the world as well, where an unelected judiciary strikes down a law passed by the people of India, by those who are representatives of the people of India. That means an unelected judiciary strikes down a law passed by an elected parliament. This doesn't happen anywhere in the world. This happens in India. Judiciary has snatched your powers. If doctrine of basic structure indeed is a doctrine, Then what is the value of the word of Pandit Nehru? Any popular demand should be capable of realization. And for that, you can amend the constitution. Let's assume for a while. Imagine a situation. I'm neither in favor nor against, but I'm just giving an example so that you understand. What if the people of India today, what if the people of India today, they don't want a secular country? They want a Hindu Rashtra. For example, it's a popular demand, for example, of the people of India. Any popular demand should be capable of realization. Why can't the Parliament of India, elected by the people of this country, amend the constitution and change secular into Hindu Rashtra? This is a popular demand of the people. Can it happen? No. Why? Because secularism is part of the basic structure of the constitution. Who says this? Judiciary. But are you elected? No. You're unelected. That's number one. Number two, Dr. Ambedkar, if you're dissatisfied with the constitution, get two-third majority and change the constitution. Wah, Modi ji, wah. We want you to be here forever. For example, I'm not his critic. I'm not in favor of him. I'm just trying to explain a point. Modi ji, you remain here forever. Forever means we don't want parliamentary democracy. We want presidential democracy. Mr. Modi, you become the president, just like we have the American president. And you become all powerful. You decide everything. And whatever you decide will be good for us. Can we convert our parliamentary democracy into presidential form of democracy? No. Why? Because unelected judiciary has said parliamentary democracy is part of the basic structure of the constitution. Is there anything as basic structure mentioned in the constitution? No. How can judiciary say this is part of the basic structure? Who is judiciary to decide that? Who is judiciary to add something else to the constitution? When there is no limitation on the powers of the parliament, why is judiciary imposing that limitation? When any popular demand should be capable of realization, why should judiciary interfere in this? If you had the two-third majority, you want to change the constitution, why should Supreme Court say stop it? After all, this is people's democracy. If people are not happy with these amendments, they will vote you out. But who are you to become the judge, jury, and the executioner? Where is basic structure doctrine mentioned anywhere in the Constitution? And this basic structure doctrine basically gives undue power to unelected judges over elected legislators. And this problem is compounded by the fact that at least there is a check on the legislators. Sunny Deol will not win the election again. Why? Because people realize that this person whom we elected with a good majority, he is not there in the parliament, not representing us. Next time he will come before the people of Punjab asking for vote, they will not listen to his dai kilo ka hath. They will show him their dai kilo ka hath and will throw him out, because there is an accountability. There is a check on the elected legislators. But there is no check on the judiciary. When there is no check on the judiciary, and this unelected judiciary on which we have no check, they are the guardians of what is this basic structure. This amounts to tyranny of unelected over elected. And that is why critics, they criticize the doctrine of basic structure, saying this gives undue powers to the judiciary. And on judiciary, we have no check. And that is why the concept of basic structure is antithetical to democracy. Because there should be no restriction on the parliament. Restriction can be imposed by the people, not by the judiciary. These legislators are accountable to the public, not to the judiciary. But then there are those who support this doctrine of basic structure. And why do they support? They give some examples. What are the examples? Srimati Indira Gandhi. Pandit Nehru was the prime minister. He passed away. Then for some time, Gulzari Lal Nanda was the prime minister, interim prime minister. And then Mr. Lal Bahadur Shastri became the prime minister. Lal Bahadur Shastri also died in Tashkent under mysterious circumstances. Then Gulzari Lal Nanda again became the interim prime minister for some time. And then Srimati Indira Gandhi became the prime minister. Srimati Indira Gandhi was called as Gungi Gudia by Morarji Desai, who became a critic of Indira Gandhi. How can this lady run this country? She is Gungi Gudia. She can't speak. It's like a doll who can't speak. How can she run this country? But then this Gungi Gudia became Durga. When in 1971, she helped in the liberation of Bangladesh, defeated Pakistan in India-Pakistan war, and ultimately led to the emergence of Bangladesh as an independent country. Something remarkable. That is why even today there are comparisons. Who is the most powerful Indian Prime Minister ever? Is it Srimati Gandhi or is it Mr. Modi? She did something spectacular. Also carried out the nuclear tests in Pokhran. So she became very, very powerful. In fact, she even split the Congress party. Until then, Congress party used to be democratic. And now this Congress party became a purely family-oriented party. And in 1971, she decided to do something. She asked the president, please dissolve Lok Sabha. There was still some time left for Lok Sabha. She asked the president, dissolve Lok Sabha. Let's have fresh elections. So that if I've defeated Pakistan in the Indo-Pakistan war, which has led to Bangladesh as an independent country, people are very happy with me, satisfied with me. I will come back to power with even thumping majority. She was right. She came to power with an even thumping majority in the 1971 elections. She herself contested from Rai Bareli in Uttar Pradesh. But then a case was filed against Indira Gandhi by her opponent Raj Narayan. Raj Narayan filed this case in Allahabad High Court. Allahabad High Court said what? Indira Gandhi should be disqualified. Why? Because of electoral malpractice. What is this electoral malpractice? Sir, according to Representation of the People Act, which is a law which governs the conduct of elections in India, you cannot use government machinery for your election purpose. No, that's true, but what has Indira Gandhi done? Sir, she has used government vehicles, government resources, government money to campaign in the elections. Okay. So do you know what she has done? She has asked the government employees to campaign for her. But that is violation. Government employees cannot take side, cannot campaign in the elections for one political party or against the other. Okay. Sir, she even brought vehicles, government vehicles, to ferry voters from their home back to the constituencies. So that is electoral malpractice, which is a crime under Representation of the People Act 1951. And if you have indulged in this offense, you should be disqualified as well. That's what the law says. Allahabad High Court said, Mr. Raj Narayan, you're absolutely right. Indira Gandhi, you are disqualified. And Indira Gandhi became the first sitting prime minister to be disqualified by the judiciary. Indira Gandhi quickly hurried before the Supreme Court, filed a petition before the Supreme Court. Supreme Court, please save me. Allahabad High Court has disqualified me, but I have some defense, I have some proof. Please help me, please help me, please help me. Supreme Court said, let's impose a stay on the Allahabad High Court order. Allahabad High Court order, which has disqualified you, we will impose a stay. You're not disqualified. Madam Gandhi was happy, said, but wait. You will continue to be a prime minister, but you cannot vote in Lok Sabha. She became the first sitting prime minister who was disqualified from voting in Lok Sabha. Why? Because we will hear this case. And if there is any merit in the argument, since this is a serious case, you are the prime minister, we are imposing a stay, but this is a temporary stay. We will hear this case. And if it is found that, yes, you are guilty of electoral malpractice, we will disqualify you. The very next day, Indira Gandhi asked the president, impose emergency. And then the emergency was imposed in June 1975. And it is argued that at that time, the president was in his bathtub. He was taking a shower. And then the prime minister calls him, said, President, said, what are you doing? I'm taking a shower, madam. Please impose national emergency. National emergency was imposed. And it is argued that this national emergency was imposed after the Supreme Court said, you cannot vote in Lok Sabha, but you can continue as the prime minister. So the government anticipated that maybe Indira Gandhi will be disqualified. Emergency was imposed. Emergency was also imposed because of Sampurna Kranti, total revolution call, which was given by JP, Jay Prakash Narayanan, who wanted complete end to corruption in the society. He started off Yatra from Bihar. There were student movements in Gujarat. And ultimately, Indira Gandhi said that there is some internal disturbance in India. And that is why we are imposing emergency. For example, today, if you say something against the government, you're called anti-national. You are an anti-national. Go to Pakistan. The same language was used by Indira Gandhi then. But at that time, she would say foreign hand. Foreign hand was basically used for CIA, the Central Intelligence Agency of United States. Whoever does something, criticizes the Indira Gandhi government, he or she was told that you have a foreign hand behind you. That means there is a CIA hand behind you. CIA wants to destabilize my government. Emergency was imposed, but when the emergency was imposed, massive changes were made to the Constitution. And we have discussed 42nd Amendment, how massive changes were made to the Constitution. But particularly significant were two amendments, 39th Amendment and 41st Amendment. What 39th Amendment said? If there is any dispute regarding the election of president, vice president, prime minister, or speaker of Lok Sabha, that dispute will be heard by a body, and this body will be created by Parliament. This was in anticipation to Raj Narayan filing a case against Indira Gandhi to disqualify her. This case was filed in the High Court, Allahabad High Court. Now, who is hearing this case? Supreme Court. What Parliament is now doing? Using Article 368. What it is doing? Amending the Constitution. What amendment? 39th Amendment. That if there is a dispute to the election of the Prime Minister, to the election of the Vice President, to the election of the Speaker, to the election of the President, that dispute cannot be filed in a High Court. That dispute cannot be filed in a Supreme Court. That dispute will be heard by a body, and this body will be created by the Parliament. But as of now, there is no body. That means as of now, there is no law. When as of now, there is no law, that means this dispute of Indira Gandhi's election will be heard by a body which is not present. This body will be created by a Parliament, which Parliament has not created. What is violated here? Rule of law. There has to be rule of law. Law has to be there. Without a law, there is nothing. 39th Amendment. 41st Amendment. Madam Gandhi was told, Madam Gandhi, because of 39th Amendment, what are you trying to do? Said, see, my case is there in the Supreme Court. Said, yes. Now it won't be there in the Supreme Court. Then where, ma'am? This dispute will be heard because this is a dispute regarding the election of the Prime Minister. I'm the Prime Minister. Yes, ma'am. This dispute will be heard by a body. Okay, ma'am. Where is that body? That parliament will create. When will parliament create that body? You're very sharp. We will never create that body. Understood, ma'am. But, ma'am, after you are gone, which means after elections, maybe, because sometimes we will have to organize elections as well. What if people vote you out of the power? Then the next government will come. They will not spare you. I said, yes, you're right. That's a good suggestion. So what should I do? Ma'am, amend the constitution again. I said, what? 41st Amendment, ma'am. What is that? 41st Amendment, we will mention that if you are a president, if you have been a prime minister, if you have been a governor, whether during your office or after you have demitted office, no case can be filed against you. That means even if I was the prime minister or a governor for a single day, even after I demit my office, no case can be filed against me. Whether it's a criminal case or a civil case, no case can be filed against me. Madam Gandhi, your best. Both these amendments were challenged to the Supreme Court. This is where we come across basic structure. If there was no limitation, if there was no restriction on the power of the parliament to amend the constitution, if there was no restriction whatsoever, parliament could have used article 368 and made any changes to the constitution, made any provisions to the constitution, then both these amendments were passed by parliament. Yes. Passed by the majority. Yes. Using article 368. Yes. But both these amendments, Supreme Court said, are unconstitutional. Why unconstitutional? Because they violate basic structure of the constitution. Rule of law is part of the basic structure, and you are violating rule of law. Parliamentary democracy is part of the basic structure, and you are violating parliamentary structure. If there was no such thing as basic structure, then both these amendments would have continued, and India would have been converted from a democracy to a one woman rule or a one party rule. That is why we say, even if Keshavananda Bharati lost his case himself, but Indian democracy won. Later on, Mr. Niren De, who was the Attorney General, who was fighting against Nani Palkhiwala in this case, he accepted that it is this doctrine of basic structure which has saved and preserved India's democracy. So, what is amendment to the constitution? Making any change to the constitution is an amendment. What is the need? The argument of Pandit Nehru and Dr. Ambedkar. Can Parliament amend any provision of the constitution? Is there restriction on the power of the Parliament to amend the constitution? Yes, there is a restriction. Restriction imposed by the Supreme Court by inventing a doctrine known as basic structure, which means Parliament can use Article 368, make any changes to the Constitution without touching what is basic structure. But this basic structure is fluid, it's not rigid. We don't have a single list of basic structure. It will keep on getting added as and when the Supreme Court decides. Because who is the final interpreter of the Constitution? The Supreme Court of India. There are some who criticize basic structure, and justifiably so. There are others who praise basic structure, and justifiably so. Depending upon what sort of question is asked in the examination, you can write in favor or against. That completes our basic structure. We'll take a break. Once we come back from the break, then we will discuss exactly what is the procedure that is followed in amending the Constitution. Clear? Done. So 7:55, 8. We'll meet 8 or 10. See you on the other side of the break. Shall we continue? Okay. Now we know that there is a need to amend the constitution, and what is an amendment and what is the limitation on the power of the parliament. Parliament can amend any provision of the constitution, but not the basic structure. And what is the current basic structure list, that I will tell you slightly later. Now let's look at what is the procedure for amendment. And for that, listen to me carefully. Use the flow that I will be using, and you will not miss out on any question on this topic from the examination. First, what we need a bill. What is a bill? Bill is a proposal. What is the proposal? To amend the constitution. Maybe add a fundamental right, add a directive principle, add a fundamental duty, add one part of the constitution, add a schedule to the constitution without disturbing the basic structure. Clear? Now, this bill has to be introduced in the parliament, passed by the parliament, sent to the president for signature. Once the president signs this bill becomes an act. Constitution stands amended. Clear? Now, this bill, where can we introduce this bill? First in Lok Sabha or first in Rajya Sabha? The bill has to be passed by both houses of the parliament. But where can we introduce this bill for the first time? This bill can be introduced in either of the two houses of the parliament. First in Lok Sabha, then in Rajya Sabha, or first in Rajya Sabha, then in Lok Sabha. Clear? But who can introduce this bill? Normally, we have two kinds of members of the parliament. One is a private member. The other is a minister. Who is a minister? If Mr. Amit Shah introduces a constitutional amendment bill, Mr. Amit Shah is a minister. Clear? Prime Minister is a minister. All the ministers of the central government, they are the ministers. Clear? But this bill can be introduced by a minister or by a private member. Who is a private member? Rahul Gandhi is a private member. Sonia Gandhi is a private member. Varun Gandhi is also a private member. Varun Gandhi belongs to the BJP. The BJP is the ruling party at the center. But a bill introduced by Varun Gandhi becomes a private member's bill. Why? Because Varun Gandhi is not a minister. So this bill, which tries to amend the constitution, this proposal can be introduced in either of the two houses by a minister or by a private member. And the prior permission of the president is not required. How? We discussed Article 3 of the Constitution. Article 3, which talks about reorganization of the states of India. There I told you that this bill, before it is tabled in the parliament, this bill should be sent to the president for his prior approval. Without the approval of the president, you cannot introduce a bill under Article 3 in the parliament. But this constitutional amendment bill, look at the flow. What is a bill? Bill is a proposal. What is the proposal? To amend the constitution. This bill can be introduced in either of the two houses. Number one. Number two, can be introduced by a minister or by a private member. Number three, it does not require the prior sanction, prior approval of the President of India. And once this bill is presented to one house, it should be passed by special majority. What sort of special majority? Majority of 2/3 members present and voting, and majority of the total membership of the house. What is the term used for majority of the total membership of the house? Absolute majority. That means this bill, which is introduced in either of the two houses, can be introduced without the prior approval of the president, can be introduced by a private member or by a minister. Let's assume that this bill is first introduced in Lok Sabha. In Lok Sabha, it should get the special majority. And what is that special majority? 2/3 of the members present and voting plus absolute majority. If Lok Sabha gives special majority to this bill, then this bill will travel to Rajya Sabha. If Rajya Sabha also passes this bill by the same special majority, then this bill will be sent to the president for his signature. And what is the option? What are the alternatives available with the president? There is only one option: sign this constitutional amendment bill. That's what we say. After the passage, it is sent for his assent, and the president shall give his assent, because president does not have the discretion. President cannot use veto. President cannot send the bill back. President cannot refuse to sign this bill. President shall give his assent to a constitutional amendment bill. Clear? Now something else. For example, there is a bill, and on this bill there is a deadlock. What do we mean by deadlock? For example, there is a bill which Lok Sabha passes. Lok Sabha agrees. Let's say there is a bill which talks about implementing Uniform Civil Code. For example, this bill is passed by Lok Sabha. What if this bill is rejected by Rajya Sabha? Rajya Sabha does not pass this bill. We say on this bill there is a deadlock, because both houses have to pass this bill. If one house accepts, the other house does not, that means there is a deadlock. Clear? For example, there are 100 students in the class. I'm asking you, should we give a break of 10 minutes? 50 are saying yes, 50 are saying no. There is a deadlock because we don't have a majority. Both are in the same measures. On this bill, there is a deadlock. Normally, for an ordinary bill, not a constitutional amendment bill, ordinary bill, if there is a deadlock, there is a provision for joint sitting. What is that joint sitting? On this bill, there is a deadlock. Now, both Lok Sabha as well as Rajya Sabha will come together, and that is what we call joint sitting of the two houses. And together in this joint sitting, they will pass this bill. In the sense, Lok Sabha has 543 MPs. Rajya Sabha has 245 MPs. Clear? If Lok Sabha passes this bill, but Rajya Sabha does not pass this bill, that means on this bill there is a deadlock. Now there is a provision for joint sitting, which means 543 plus 245, which means 788. These MPs will come together, and these 788 MPs will have to pass this bill by simple majority. And what is the simple majority in this case? Close to 390. Clear? 395, for example. That means Lok Sabha, which has 543 MPs, their will prevails. Because who has more composition, more numbers, more strength? It's the Lok Sabha. So whenever there is a bill which is sent to joint sitting of the two houses, it is basically the will of the Lok Sabha which prevails, because Lok Sabha will have more representation, more strength. But a constitutional amendment bill, if one house accepts it, other house rejects it, there is no provision of joint sitting of the two houses. That means this bill has to be passed by both houses of the parliament separately, without any purpose, without any need to go through the joint sitting of the two houses. Both houses of the parliament, they have to separately, independently pass a constitutional amendment bill by special majority. This is how the constitutional amendment bill is passed. And once it is passed, the constitution stands amended. Is that clear? Now something else. Lakshmikant says this, although I disagree with Lakshmikant. Lakshmikant says that there are three ways in which constitution can be amended: by simple majority, by special majority, and by special majority plus ratification by more than half of the states as well. But I disagree. Why? And I have a solid reason to disagree. And listen to me carefully. Constitution can only be amended by special majority. Constitution can be amended only by special majority. If this statement comes in the examination, mark it correct. This is correct. Constitution can be amended only by special majority. But then there are some provisions in the Constitution which you can change, which you can modify, which you can alter without using Article 368. When you don't use Article 368, that means you don't need special majority. When you don't need special majority, then what is the majority that you need? You need simple majority. For example, we discussed formation of new states. When a new state is created under Article 2, a new state is created under Article 3. What will happen because of this? The name of the state will be mentioned in first schedule. The representation of the state in the Rajya Sabha will be mentioned in fourth schedule. But do we say it is amendment? No. Although these make changes to Schedule 1 and Schedule 4, but we don't call them amendment. These changes made to the Constitution itself says, shall not be deemed as amendment to the Constitution. When it is not deemed as amendment, that means you don't need special majority, which means you don't need Article 368 of the Constitution. Those provisions of the Constitution which can be changed by simple majority, this is the list. But if you make changes to these provisions, we don't call them amendment. When we don't call them amendment, that means we don't need special majority. When we don't need special majority, that means we don't have to take the route of Article 368. That is why Lakshmikant says some provisions can be amended by simple majority. It's not the correct explanation. There are some features of the Constitution which can be changed, but those changes are not deemed as amendment. That means they are not amendment. But there are some features which can be altered, modified by using simple majority. For example, formation of new states. There are some states in India which have legislative council as well. And we will discuss in state machinery what is the need for a legislative council. But creating a legislative council, establishing a legislative council, abolishing a legislative council, Parliament will have the power to do that. Parliament does that with simple majority. That means although you are making change to the Constitution, you are adding a legislative council to, let's say, Chhattisgarh. You are removing a legislative council from Karnataka. Although you are making changes to the Constitution, but these changes are not deemed as amendment, which means you don't need special majority, which means you need simple majority. Constitution said originally under Article 124 that there shall be Supreme Court of India headed by Chief Justice of India and not more than 7 judges. These are what we call puisne judges, other judges other than Chief Justice of India. So what did the Constitution say? There shall be a Supreme Court of India headed by the Chief Justice of India and not more than 7 other judges. These other judges are known as puisne judges. Can the Parliament increase the number of judges? Yes. And Parliament has done that. Has increased the number of judges from 7 to right now we have 33. That means increase the number of judges. This can be done by the Parliament by simple majority. That means you don't have to amend the Constitution for that. You don't have to use Article 368 for that. Similarly, Constitution said, what is the official language of the Union? Hindi. But English will be used for 15 years. After 15 years, English will be stopped from being used. We will continue only with Hindi. Hindi will be the official language of the Union. But Constitution further said, after this 15-year limit is over, after this 15-year limit has expired, Parliament can still say English will continue beyond a period of 15 years. For that, Parliament does not have to amend the Constitution. Parliament just needs to pass a bill by simple majority. Make any changes to 5th and 6th schedule, which we will discuss in schedules chapter. Those can be done by simple majority. That means first, what is an amendment? We know that. What is the need to amend the Constitution? We know that. Can Parliament amend any provision of the Constitution? No, because there is a limitation, doctrine of basic structure. Parliament can use Article 368, make any changes to the Constitution without disturbing the basic structure. But then what is the procedure to amend the Constitution? For that, we need a bill, and this bill should be passed by special majority. That means Constitution can only be changed by special majority. But then there are some provisions in the Constitution, and that is why we say Indian Constitution is flexible, can be easily changed, can be easily altered, can be easily modified. And all these changes are not deemed as amendment. They're not called amendment. When they're not called amendment, that means they are not requiring special majority. That means we don't need Article 368. And what are those provisions of the Constitution which can be flexibly changed by the Parliament by using simple majority without using Article 368 or special majority? These are those provisions by simple majority. But then majority of the Constitution can be changed by special majority. For example, you have to change fundamental rights, you have to change directive principles of state policy. All these changes can be made only by special majority. But there are some changes, and those changes affect federal structure, which we have discussed in majorities, because in majorities we discussed various flavors of special majority, and we discussed flavor 3 of special majority. In that flavor 3, I told you, if Parliament wants to change, modify, amend some of the federal features of the Constitution, those federal features can be changed if Parliament passes a law by special majority. But before this bill is sent to President for signature, this bill is sent to the legislatures of all the states in India, including those union territories which have a legislative council, which have a legislative assembly. That means this bill will be sent to all the state legislatures for their ratification. And if these state legislatures ratify this constitutional amendment by simple majority, that means Parliament will pass a bill. And what is that bill? For example, NJAC. What is NJAC? National Judicial Appointments Commission. Because you know, right now we have a collegium system where the judges are appointed by themselves, where the judges recommend names to the government, and it is binding on the government to appoint only those people as the judges of the Supreme Court and High Courts. Clear? But in the year 2014, the Parliament of India enacted a law known as NJAC, National Judicial Appointments Commission, saying that we will replace collegium system. Collegium will be replaced by NJAC. So instead of collegium recommending to the president, judges, the names of the judges, it will be this body which will recommend names to the president for appointment as the judges of the Supreme Court and High Courts. This NJAC bill was passed by both houses of the Parliament by special majority. Then this NJAC bill was sent to all the state legislatures. When more than half of the state legislatures accepted NJAC by passing a resolution by simple majority, then NJAC bill was sent to the president. President looked at this bill. Okay, this bill has been passed by both houses of the Parliament by special majority, has been ratified by more than half of the states by simple majority. Now I will sign this bill. NJAC becomes an act. Why NJAC required ratification by the states? Because if the Parliament wants to amend any federal feature, and one such federal feature is if you want to change the provisions relating to High Court and Supreme Court, for that you need to seek the permission, ratification of the states as well. That means there are some provisions in the constitution which can be changed by simple majority, although we don't call them amendment. Second, majority of the articles, all the parts of the constitution can be changed by special majority. States are not consulted there. But if the parliament wants to amend, modify, alter those features which are mentioned here, which are known as federal features, to modify, amend these federal features, the parliament has to then refer this bill to all the state legislatures. And only when half of the state legislatures pass a resolution by simple majority, parliament will pass by special majority, states will accept by simple majority, then constitution stands amended. Clear? Now NJAC is unconstitutional, yes, because even an act of the parliament, even a constitutional amendment act, if it violates basic structure, that will be declared unconstitutional. Supreme Court said in 2015 that NJAC violates basic structure, violates independence of judiciary, which is part of the basic structure, violates the primacy of Chief Justice of India in judicial appointments. That's also part of the basic structure. Whether this is good, bad, we'll discuss that in judiciary. But here, amend any federal features, you need ratification by half of the states as well. And what is this list of basic structure? Supremacy of the constitution is part of the basic structure. Rule of law is part of the basic structure. Objectives mentioned in the preamble, part of the basic structure. Relationship between fundamental rights and DPSP is part of the basic structure. Parliamentary form of government, free and fair elections, limitations upon the amending powers conferred by Article 368. That's also part of the basic structure, which means Parliament does not have unlimited power to amend the constitution. Independence of judiciary, social justice, Articles 21, when we read it with Articles 14 and 19, they're part of the basic structure. Article 20 and 32, part of the basic structure. Article 15 and 14, when we read it together with 16.4, 4A, 4B, they are also part of the basic structure because they implement social justice. Then primacy of Chief Justice of India in judicial appointments. This is also part of the basic structure. Secularism is part of the basic structure because that is one of the objectives mentioned in the preamble. And by looking at this amendment provisions, D. Oliver and C. Fusaro, constitutional experts, they write in their book, which is basically a comparative study where they compared the constitutions of important countries of the world and compared how they deal with amendment, how these are amended. The term that these two gentlemen have used for Indian constitution is that Indian constitution is flexible rigidity. Flexible rigidity in the sense, there are some provisions in the constitution which you can change without Article 368, which means by simple majority. There are some provisions which you can change by special majority, that means slightly difficult. Then there are some provisions which are related to federal features. Those, if you want to change, you need permission by more than half of the states as well. That means depending upon what you want to change, the difficulty level changes. Some changes are very flexible, easy to change. Some are little difficult, some are very difficult to change. And that is why there is no one rule through which you can change the constitution. There is no one method through which you can change the constitution. There is an element of flexibility, there is an element of rigidity as well. So together it is known as flexible rigidity. That completes our discussion on amendment to the constitution, the doctrine of basic structure. Any questions now? Let me know. Sir, but cooperative societies were a state subject under 7th schedule. Union passed the Cooperative Society Act without seeking approval of 50% legislature. How is that possible? Are state lists not part of the federal features? Yes, they are. And that is why we will discuss it in Union Executive. That constitutional amendment was struck down by the court. And we'll discuss that. Rigidity means that some provisions are very difficult to change, which require special majority. That means you are very rigid. You don't change. I'm telling you, don't be rigid. Change yourself. That is how you will clear the examination. Clear? Simran, private member. Private member is the member of a house who is not a minister. So if there are 545 MPs in Lok Sabha, not all of them are ministers. Shrimati Irani is a minister. Mr. Amit Shah is a minister. Mr. Rajnath Singh is a minister. Mr. Modi is a minister. But who are these others who are not ministers but are members of Lok Sabha? They are called private members. But sir, Lakshmikant is talking about these three methods only. Why are you dissatisfied? I'm not dissatisfied with special majority and ratification by half of the states. I'm only concerned with the use of the term that constitution can be changed by simple majority. Constitution cannot be changed by simple majority. Constitution can be changed only by special majority. That too only by using Article 368. Then, sir, how these things can be changed? We don't call them amendment. Constitution does not call them amendment. That is why they are not amendment to the Constitution. In future, any article can be treated as basic structure. Yes. Balance between fundamental rights and DPSP, that we have discussed yesterday in Minerva Mills case, 1980. The Supreme Court said if you are giving primacy to all DPSPs over three fundamental rights, you're violating the harmony, you're violating the balance, which is part of the basic structure. Done? Okay. One more thing. I somehow miscalculated the time today. So I thought we will discuss some provisions related to DPSPs. Then we will look at Keshavananda Bharati judgment, the doctrine of basic structure, amendment. And I think I won't be left with enough time to discuss something else. That is why in your PPT, I have not added more topics. But even if it's not in the PPT, we can add the slide and we will start. Clear? We will now discuss part 5 of the Constitution, which deals with Union Executive. The PPT will be provided tomorrow. Don't worry about that. Even this is the PPT I'm writing. I'll write everything. Don't worry. I remember everything. Touch wood. Union Executive consists of President, Vice President, Prime Minister, Council of Ministers, and the Attorney General for India. Clear? We have discussed preamble, then part 1, Union and its territory, part 2, citizenship, part 3, fundamental rights, part 4, directive principles of state policy, part 4, capital A, fundamental duties. Then we looked at the amendment of the Constitution and the doctrine of basic structure. So first big portion of Indian polity is over. Now we will have to look at Union Executive, then we will look at Union Legislature, then we will look at state machinery. And in state machinery, we will discuss state executive and state legislature. Clear? Union Executive consists of President, Vice President, Prime Minister, Council of Ministers, and the Attorney General for India. And we have to discuss all these important institutions one by one. First, we will look at President, then we will look at Vice President, Prime Minister, Council of Ministers, and the end, Attorney General for India. Clear? Let's first look at the President of India. Constitution says under Article 52 of the Constitution, which is considered to be the shortest article in the Constitution, It says there shall be a president of India. The shortest article under the Constitution. There shall be a president of India. What does that mean? This term shall makes it clear that this office is necessary. Our constitutional scheme cannot be envisaged to function even for a brief moment without somebody occupying the post of the President of India. There has to be the President of India occupying his or her chair at all times. We cannot imagine our polity without the office of President. Office of President is necessary. There shall be a President of India. That's Article 52. And Article 53 says all the executive powers are vested in the name of the President of India. All the executive powers are vested in the name of the President of India. That means Article 52, there shall be a President of India. That means we cannot imagine our polity without somebody occupying the post of the President of India. There has to be President. If President is not there, someone else has to occupy that post. And I'll tell you who is that person. But somebody has to occupy the post of the President of India, because Constitution makes it clear under Article 52, there shall be a President of India. And the very next article, Article 53 says, all the executive powers are vested in the name of the President of India. But now there is a problem. What is the problem? This term, executive power, is not defined in the Constitution. So we don't know what is an executive power. When we don't know what is an executive power, why is it that we don't know? Because it is not defined in the Constitution. When it is not defined in the Constitution, then what should we do? We go to the court. The court is the final interpreter of the Constitution. And the court said something in 1954. Ram Javaya Kapoor. The Supreme Court said executive power means laying down the policy, implementing the policy, carrying out general administration of the country, running the government on a day-to-day basis. All these are executive powers, and all these executive powers are vested in the name of the President of India. Sir, it is not still clear. What do we mean by general administration of the country, carrying out general administration of the land, carrying out policy, laying down policy, implementing the policy? Sir, this is not clear. Then what do? We go to constitutional experts. You tell us, please, what do we mean by this executive power? And we looked at Dutt and Bradley. They wrote a book, Constitutional Law. And they were asked, can you tell us what is this executive power? Dutt and Bradley basically said executive power is a residue. What is a residue? Leftover. What is a leftover? For example, I gave the example of photosynthesis. H2O, CO2, because of the presence of sunlight, chlorophyll, then it leads to C6, H12O6, plus 6 times oxygen. What is this oxygen? It's a residue. What is this oxygen? It's a byproduct. What is the byproduct? Something which is not aimed at. What is not aimed at? You're preparing for the civil services examination. What is your aim? To become a civil servant. But then the byproduct is, using this knowledge, you may also win a debate contest in your college or university. I get lots of mails from the students, sir, because of your lectures, I won the first prize, second prize in the debate contest. But that's a byproduct. That is not something that you aim at. You're not joining these classes because you want to win a debate contest. You are here to become a civil servant, to clear the examination. So the purpose of the green leaf is to manufacture glucose. Oxygen is a byproduct. It's basically a residue. It's basically leftover. Similarly, Dutt and Bradley, and later on Wade also wrote this book. Wade also was part of this book when he wrote this book. They said executive power is a residue, is a leftover. When you exclude legislative power, when you exclude judicial power, the job of the legislature is to make laws. That's the legislative power. The job of the judiciary is to pronounce whether the laws are constitutional or not. The job of the judiciary is to give punishment to those who have violated the laws. All the powers that a state has, if you exclude legislative power, if you exclude judicial power, whatever else is left, whatever is the residue, that is the executive power, and that executive power is with the President of India. So think of anything except legislative power, except judicial power, whatever else that you can think of, whether it is laying down foreign policy, whether it is implementing the laws, whether it is ensuring national security of India, whether it is ensuring the sovereignty and integrity of India, anything that you can think of, anything that you can assume of, minus legislative powers, minus judicial powers, whatever else is left, that's the executive power, and that executive power is with the President of India. But now you are surprised, confused, shocked. Sir, is the President of India so powerful that number one, Article 52 says there shall be a President of India? There is no such term as there shall be a Prime Minister of India. That's not mentioned in the Constitution. But there is a thing that there shall be a President of India, and all the executive powers are vested in the name of the President of India. So President of India is the most powerful individual in India. Is that true? No. Why? Because you don't have to look at Article 52 and Article 53 in isolation. You have to look at Article 52 and Article 53 together with Article 74 of the Constitution. And what is Article 74? There shall be a council of ministers headed by the Prime Minister to aid and advise the President. There shall be council of ministers headed by the Prime Minister to aid and advise the President. This is Article 74. On this, there was a lot of dispute. What was the dispute? Let's look at the history. When the Constituent Assembly was debating the Constitution, first Sachindanand Sinha, he was the interim president of the Constituent Assembly. Then who was the permanent president of the Constituent Assembly? Dr. Rajendra Prasad. Dr. Rajendra Prasad was basically presiding over the Constituent Assembly when the Constituent Assembly was writing and drafting the Constitution. And then there was a discussion on what sort of democracy, what sort of government do we want to establish in India. And the Constituent Assembly members, they realized that we should look at parliamentary form of democracy and not presidential form of democracy that is seen in United States of America. Why? Because they looked at pros and cons. What will work better for India, whether it is parliamentary democracy or presidential democracy, presidential or parliamentary? In presidential form of democracy, the government is stable. Why is the government stable? Because the government is not accountable to legislature. For example, Donald Trump. He was the president of the United States of America for 4 years. Do you know he was impeached by one house of the parliament? One house of the US Congress. House of Representatives impeached Donald Trump. Not once, twice. Yet he continued to be the president of the United States of America because they have a provision. The provision is if House of Representative impeaches you, the Senate, which is the other house of US Congress, it has to convict the president. That means Senate will have its own inquiry and see whether President Trump has committed treason or not, which is the highest offense in United States. If the Senate convicts you, then you are removed from your office. That means in presidential form of democracy, the government is stable because it is not accountable to legislature. The term of the president is 4 years and they complete 4 years in office. But in India, in parliamentary democracy, the government continues as long as you have the majority in the legislature, which means prime minister and his ministers, they will continue as long as they have the majority in the Lok Sabha. The moment they lose majority in Lok Sabha, they are gone. This happened with Mr. Kamal Nath as well. He was the chief minister of Madhya Pradesh, but suddenly his party members resigned. Close to 22 MLAs resigned, which means basically his majority in legislative assembly reduced. He had no other option but to resign. Same happened with Mr. Uddhav Thackeray. He had to resign. Why? Because he lost the majority. That means the governments in parliamentary democracy, they're not stable. Unless and until you have the majority in Lok Sabha, you have the majority in the legislative assembly, the government cannot survive. The government's survival is dependent upon whether your party has the majority in Lok Sabha or not. It doesn't matter to the President Biden if the Democrats have the majority in House of Representatives or the Senate. He will still continue and complete his 4-year term. But the problem with presidential form of democracy is that it may ignore minority interests. Minority interest in the sense, Joe Biden can choose his ministers, and these ministers should not be part of the legislature. Mr. Blinken, the Secretary of State, the Foreign Minister of United States, is not part of the legislature. So the president can choose anyone to become his minister, and you are not the member elected by the public, which means maybe Donald Trump would choose only the whites and not the blacks, would choose those who are from a particular state and exclude others. That means this presidential form of democracy may ignore minority interests as well. But that cannot happen in a parliamentary democracy. In parliamentary democracy, if you are the prime minister, what are the calculations that you keep in mind? Okay, there are elections in Karnataka, so there should be some members from Karnataka part of my council of ministry. There should be representation for SCs, there should be representation for STs, there should be representation for OBCs. Minorities may not matter, but there can be minority ministers as well. So this parliamentary form of democracy, in a parliamentary form of government, the prime minister chooses his ministers by looking at the various diversity that the country has. And that is the beauty about parliamentary democracy. And the members of the Constituent Assembly, when they had to debate, should we adopt presidential form of democracy or a parliamentary form of democracy? They said we will choose parliamentary form of democracy. Why? Because although it may not be stable, because the governments may be removed if they don't have majority, but at least it will be the representative of the entire country. And India is unique. India is diverse. People from different castes, different regions, different religions, different languages. That is why we need this government, which should be diverse, respecting the diversity of the society that we live in. And at the same time, we will adopt parliamentary form of democracy because we are exposed to it. Britain, they have a parliamentary democracy. And Britain governed us for more than close to 2 centuries. And Britain also introduced some element of parliamentary democracy in India. So since we are exposed to parliamentary democracy, since we know how parliamentary democracy functions, we will adopt parliamentary form of democracy. Dr. Rajendra Prasad was hearing this. Dr. Rajendra Prasad said, yes, we agree. I agree, we agree that this president will be a nominal figure, will be a constitutional figure. Although on paper all powers are given to the President of India, but President will not have the discretion. President will not have the power to do anything that he wishes to do. President has to do only those things which are told to him by the Prime Minister and his Council of Ministers. So this president will be like an ornamental figure, will be like a titular head. The real power will be with the Prime Minister and the Council of Ministers because they are directly elected by the public. President is not directly elected by the public. But we need president because there is Queen in England. If they have a parliamentary democracy where the real power is with the Prime Minister Rishi Sunak and his ministers, but then we have the king as well. Previously, we had the Queen as well. But Queen was only the ornamental figure, a constitutional head, a titular head. The real power was with the Prime Minister and his Council of Ministers. Same thing we will borrow in India as well. We will have a president, but he will only be a nominal head, only be a figurehead. The real power will be with the Prime Minister and his Council of Ministers. Dr. Rajendra Prasad also said, yes, I agree. This is how parliamentary democracy is functioning. And that's how Constitution was enacted. But then came the tussle. Dr. Rajendra Prasad is now the President of India. Pandit Nehru is the Prime Minister of India. Came one conflict. And the conflict was Somnath Temple was being redeveloped. Dr. Rajendra Prasad decides that I will go and visit Somnath Temple and inaugurate it. Pandit Nehru wrote a letter, you should not go. Said, why? Because we are a secular country. As a secular country, we should not be identifying ourselves with a particular religion. If you go to inaugurate the Somnath Temple, it may give a sense that the head of the state is practicing religion, is promoting a particular religion, which goes against the secular credentials of India. Dr. Rajendra Prasad ignored, went ahead, inaugurated the Somnath Temple. And then there were a few more points of conflict between the Prime Minister and the Council of Ministers. And then came one important matter. The President, Dr. Rajendra Prasad, was addressing law students at a university in Calcutta. And there he said, it's not mentioned anywhere in the Constitution that whatever advice is given by Prime Minister to me is binding on me. So I have the individual power as well. I can run the government as well. I can decide what is good, what is bad. Rajendra Prasad was told, but how can you say this? He said, look at Article 74 of the Constitution. But for that, I will first tell you what is Article 52. There shall be a President of India. That means you can't function without me. Article 53, all executive powers are vested in my name. And executive powers are remove legislative powers, remove judicial powers, whatever else is left, that's the executive power, and those executive powers are in my name. And then Article 74, there shall be a Council of Ministers headed by the Prime Minister to do what? To aid and advise me. They're here just to advise me. Where is it mentioned that whatever advice they give me that's binding on me? It's not mentioned. And then matters went to the court. Shamsher Singh versus State of Punjab, 1954. What was this case? Shamsher Singh was a judge appointed to a court in Punjab, but he was on probation. What is probation? For example, once you are recruited, for 1 or 2 years, you will be in probation. If you complete that probation period, then you are converted fully. That means you will now become a permanent judge. He was in probation, and then he was dismissed from the service, removed from the service. Who removed him? The Chief Minister of Punjab, the government of Punjab. He approached the Supreme Court and said, my lord, how can the Chief Minister, the government of the state of Punjab, remove me, dismiss me from the service? That is not the power available with the government. That is the power available with the governor. Governor is the head of the state in Punjab. Similarly, we have the President of India as the head of the state at the central level. So this power should be exercised by President or the governor in their individual capacity because they have the power. Supreme Court said no. We have a parliamentary form of democracy. And in a parliamentary form of democracy, the governor or the president, they have to only act on the aid and advice of the government. That means whatever advice is given by chief minister and his ministers to the governor, given by prime minister and his ministers to the president, it is binding on the president because president does not have discretion. President has no discretion. President can't do anything on his own. So if Shamsher Singh is to be dismissed, government has to say. Governor and the president, they have to only abide because we follow parliamentary democracy. Matter went to the court again. The case was UNR Rao versus Union of India. UNR Rao versus Indira Gandhi and Union of India. What was the case? My lord, there are some terms mentioned in the constitution. What are these terms? If the president is satisfied, he can impose national emergency. If the president is satisfied, he can impose president's rule. If the president is satisfied, he can impose financial emergency. If the president is satisfied, he can promulgate an ordinance. If the president is satisfied, he can do this. If the president is satisfied, he can do that. What is the satisfaction of the president? Supreme Court said it is not the personal satisfaction of the president. It is the satisfaction of the Council of Ministers, headed by the Prime Minister. Sir, what does that mean? If the Prime Minister and his Council of Ministers advise the President, impose national emergency, only then he can impose. Promulgate ordinance, only then you can promulgate. Impose President's rule, only then you can impose President's rule. If the Prime Minister and his Council of Ministers advise the President, impose financial emergency, only then you can impose financial emergency. Basically, if the Prime Minister and his Council of Ministers tell the President, stand up, he has to. Sit down, he has to. No, stand up, sit down, stand up, sit down, go. Whatever advice is given by Prime Minister and his Council of Ministers, that is binding on the President because our model is based on British parliamentary model. Our model is based on British parliamentary model. And in that British parliamentary model, the real power is with the Prime Minister and the Council of Ministers. The President is only a nominal, is only a titular, is only a constitutional head. The real power is with the Prime Minister and his Council of Ministers. But perhaps all these things were communicated to Indira Gandhi by her father. Beta, when, if at all, you become the Prime Minister, just keep track of Article 74. Papa, what is Article 74? It says there shall be Council of Ministers headed by the Prime Minister to aid and advise the President. Keep track of this because it is not mentioned that your advice will be binding on the President. This is a fictional conversation. I don't know whether Pandit Nehru has told this to his daughter or not, but this is just to make you understand. And when Indira Gandhi became the Prime Minister, Constitution was amended. 42nd Constitutional Amendment Act, something I've told you, is considered to be the mini revision of the Constitution where major changes were made to the Constitution. Article 74 was amended. Article 74 previously said, there shall be a Council of Ministers headed by the Prime Minister to aid and advise the President. Only this was mentioned under Article 74 of the Constitution. 42nd Constitutional Amendment Act, 1976, Article 74 was amended. And now it was mentioned who shall act on that advice. There shall be Council of Ministers with the Prime Minister at its head to aid and advise the President, full stop. That's what was mentioned in the original Constitution. 1976, another line was added, who shall act on that advice. That means whatever advice is given by the Prime Minister and his Council of Ministers is binding on the President of India, which means President is now a rubber stamp. 1976, this was the period of emergency, when emergency was imposed. Emergency was imposed in 1975. It continued till 1977. And in 1977, elections were announced. And in 1977, all the opposition parties decided to come together. And they created a Janata Party, where all the opposition got together and their principal objective was to defeat Indira Gandhi. And they came up with a promise. They promised the people of India that we will undo all the changes that are made to the constitution during emergency. We will restore constitution to its original glory. The original constitution, which has been amended, modified, abridged, and which has been changed beyond recognition by Indira Gandhi during emergency. We will restore the original constitution. President was also looking at this, and President was also praying that this Janata Party should come to power because my powers will be restored. President was very happy. Elections were held. Indira Gandhi lost election. In fact, she could win only 2 seats from the entire North India. From South India, she got a lot of support. Why? Let's not get into that. But Janata Party won the power. Morarji Desai became the Prime Minister. President basically told Morarji Desai, sir, what about your promise? What promise? You promised the people of India that you will restore the constitution to its original glory. Yes, 100%. Sir, is Article 74 also part of that old glory? Said 100%. Why not? We'll change Article 74 as well. Please don't worry. Thank you so much. Article 74 was now changed. Article 74 was now changed. 44th Constitutional Amendment Act, 1978. President, be happy. We have something good for you. President is waiting, praying 100 times. Provided the President may ask for reconsideration of that advice and shall act on the advice retendered. President, be happy. Said, what? We have introduced a constitutional amendment bill in the parliament. We will change Article 74. What was originally mentioned in the constitution? There shall be Council of Ministers headed by the Prime Minister to aid and advise the President. Very good. And what did Indira Gandhi do with this? Introduced who shall act on that advice. What we will write, provided the President may ask for reconsideration of that advice. If the advice is, previously what was the advice? Stand up, sit down, go out, come back. Clear? It was binding on you? Yes, sir. Impose national emergency. It was binding on you? Yes, sir. Impose president's rule. Binding on you? Yes, sir. Impose financial emergency. Binding on you? Yes, sir. Promulgate an ordinance. Binding on you? Yes, sir. Now we will give you the power. You can send the matter back and ask us and tell us, please reconsider this advice. Very good, sir. This is superb. Thank you so much. So I can now say, no, I will not impose national emergency. No, I will not impose president's rule. No, I will not impose financial emergency. No, that you can't do, but you can always seek reconsideration. You can say, can you please reconsider? Do we really need to impose national emergency? Can you reconsider? Should we really impose president's rule? Can you please reconsider? Should we impose financial emergency? Can you please reconsider? Should we promulgate an ordinance? Okay, then what will happen after I say this reconsideration? After that, the government, the Prime Minister, Council of Ministers will reconsider. But then whatever advice they give you, that is binding on you. What does that mean? That means if Indira Gandhi told you impose national emergency, You had no option. Now you can tell me, please reconsider. Is there a need to impose national emergency? And if I tell you yes, it is binding on you. President said, but this is cheating. This is more or less the same thing. This is like Indira Gandhi would tell me, go out. I had to. Now you will tell me, go out. I can only say, can I please sit? Said, no, go out. I have no other option but to go out. This is cheating. This is not restoration of the old constitutional glory. So this is parliamentary democracy, because the real power is with the Prime Minister and his Council of Ministers. You are only a nominal head. You are only a constitutional head in a parliamentary democracy, which means President is now a rubber stamp. He does not have the real power. The real power is with the Prime Minister and his Council of Ministers, which means no discretionary power. What is discretionary? Something that the president can do on his own without the aid and advice of the Prime Minister and his Council of Ministers. So something which the president can do on his own without the aid and advice of the Prime Minister and his Council of Ministers, that is what we call discretionary. But president does not have the discretionary power. There is only one discretionary power that is available with the president: choosing the Prime Minister. He can choose anyone as the Prime Minister. That is his discretion. But that discretion is limited by a lot of factors. We will discuss that in Prime Minister. But you should keep in mind that the only discretion which the president may have is appointing the Prime Minister. Apart from that, he has no discretion whatsoever. So what is Union Executive chapter all about? We have to discuss Union Executive. Who all are part of the Union Executive? President, Prime Minister, Vice President, Council of Ministers, and the Attorney General for India. And we have to look at all these institutions one by one. Very important for the exam. First, we will look at President. So what is the President? We say Article 52, the shortest article in the Constitution, it says there shall be a President of India. That means our constitutional scheme cannot be envisaged to function even for a brief moment without somebody occupying the post of the President of India. And all the executive powers are vested in the name of the President of India. Does that mean the President is so powerful that without him or her we cannot function? And all the executive powers are vested in his or her name? No. Why? Because you have to look at Article 52 and 53 in association with, by linking it with Article 74 of the Constitution. And because of two constitutional amendments in 1976 and 1978, what is the current constitutional position of the president? There shall be Council of Ministers headed by the Prime Minister to aid and advise the president, who shall act on that advice, provided the president may ask for reconsideration of the advice. And whatever advice is retendered, it is binding on the President of India. Which means, long story short, Supreme Court has clarified that we follow parliamentary form of democracy, where the real power is with the Prime Minister and his Council of Ministers. Supreme Court has clarified that our democracy is modeled on the lines of the British constitutional scheme, where the real power is with the Prime Minister and his Council of Ministers. Constitution has clarified, the Supreme Court has clarified, that any term which is used in the Constitution, which talks about satisfaction of the president, that is not the personal satisfaction of the president. That is the satisfaction of the Council of Ministers headed by the Prime Minister. So long story short, there are no discretionary powers available with the president. The president is a mere rubber stamp. That's the position of the president. And the only discretionary power that may be available with the president is the appointment of a prime minister. How not, that we will discuss in Prime Minister. But here, just keep in mind, appointment of the Prime Minister is the discretionary power of the president. Apart from that, there is no discretionary power available with the president. Any questions as of now? Let me know. Rigidity means change by special majority under 368 and under 368 plus state ratification. Yes. Sir, what about veto power? That we will discuss in the powers of the president. That is related to the bills. That means on legislative matter. On executive matter, president has no discretion. We'll discuss that in veto powers. Sir, president has pocket veto. My dear, I have not completed the story. Picture abhi baki hai. Whatever I have spoken right now, just tell me from that area, do you have any doubts? Once the entire president chapter is over, then you will realize all your other doubts, veto, pocket veto, absolute veto, qualified veto, suspensive veto, all that will be clear. Sir, at least give some respect to her. Don't say rubber stamp, she is head of the state. My dear, these are not my words. I've told you in the first class itself. All the characters in this polity lecture are fictional. Any resemblance to any person living or dead is purely unintentional. These are not my words. These are the words of constitutional experts. They call the office of president rubber stamp. If I don't tell you that, then how will you clear the exam? Can PM alone advise the president without discussion with Council of Ministers? No. It has to be a collective decision of the cabinet, and that we will discuss in Prime Minister. What is cabinet? Okay. Done? Now let's look at what are the qualifications required for somebody in order to contest the election of the President of India. Who is qualified to become the President of India, to contest election to the post of the President of India? Qualification number one, you should be the citizen of India. Qualification number two, must have completed 35 years of age. Qualification number three, should be eligible to become a member of Lok Sabha and should not hold any office of profit. Who is qualified to become the President of India? Qualification number one, if you are a citizen of India, yes. Have you completed 35 years of age? Yes. Are you eligible to become a member of Lok Sabha? You should not be the member of Lok Sabha. If you are a member of Lok Sabha, resign. Then you can contest president's election. But are you eligible to become a member of Lok Sabha? Sir, what is that eligibility? Is your name mentioned in the voter list of any parliamentary constituency in India? Is your name mentioned as a registered voter in any of the parliamentary constituencies of India? If yes, then you are eligible to become a member of Lok Sabha. If all these conditions are met, means you are qualified to become the President of India, qualified to contest election to the post of the President of India. What are the qualifications? Citizen of India, 35 plus years of age, should be eligible, should not be the member of Lok Sabha, should be eligible to become a member of Lok Sabha. What is that eligibility? Your name should be mentioned in voter list of any parliamentary constituency in India. Any 543 constituencies of India. If your name is mentioned as a voter list, in the voter list, you are qualified to contest election to the post of the President of India. And also, you should not be holding any office of profit. And what is this office of profit? We will discuss in Parliament. Parliament, why? Because even legislators, MPs, of Lok Sabha and Rajya Sabha, they should not be holding office of profit. So we will discuss in Parliament what is this office of profit. Here, just keep in mind, president who is qualified to become the president or to contest elections. If you are a citizen of India, must have completed 35 years of age, should be eligible to become a member of Lok Sabha, should not be holding any office of profit. Clear? And then you have to contest election. Who organizes this election? Election Commission of India. And the election of the President of India is done. Number one, President is elected in an indirect election by the Electoral College through a system of proportional representation system. That's what we call PRS. Through single transferable vote, STV, by secret ballot. Who is the President of India? Srimati Draupadi Murmu. She is the President of India. What does Constitution say? There shall be a President of India. That means this seat cannot remain vacant. Someone has to occupy this seat. And all the executive powers are vested in her name. But then the real power is with the Prime Minister and his Council of Ministers. Whatever advice Mr. Modi and his cabinet gives to Council of Ministers, give to President, it's binding on her. She may ask for reconsideration of that advice. But if the same advice is given, then she has no other option but to accept. For example, I have committed a crime. Court said you are guilty, you are to be hanged by your neck till death. What is the alternative? I file a mercy petition before the President. President, please have mercy on me, save me, don't give me death sentence. This is not the personal power of the President. President cannot say, okay, I forgive you, I have mercy on you, I will pardon you. President will pardon me only on the advice of the Prime Minister and his Council of Ministers. If they say pardon him, she has to pardon me. If this advice don't pardon him, she cannot pardon me. That means President does not have the discretion at all. Clear? But then who is qualified to contest the election of the President? We know the qualification. But how is this election conducted? How is the President of India elected? We saw the election recently. President is elected in an indirect election by the members of the Electoral College through a system of proportional representation system by means of single transferable vote through secret ballot. And I will explain all these 5 terms one by one. First is indirect election. Is President of India elected by the people? Tell me yes or no. As expected. No, 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 no. No. Okay. And the answer is yes. Is the President of India elected by the people? Yes. But not directly. Indirectly. Indirectly through whom? Through the members who are present in Parliament. Through the members who are present in the state legislature. Do you elect MLAs to your state legislature? Yes. And these MLAs elect the President of India. That means you are electing the President of India, but not directly, indirectly through your representatives. Do you elect MPs to Lok Sabha? Yes. Do these MPs vote to elect the President of India? Yes. That means you are electing the President of India, but not directly, indirectly through your representatives in Lok Sabha. That means the President of India is elected by the people, but not through direct election. People don't directly vote to elect the President of India. Indirect election. Why indirect election? Constituent Assembly debated this. Some were in favor of direct election, some were in favor of indirect election. And ultimately, those in favor of indirect election, they prevailed over those who wanted direct election. Why did they prevail? Number one, they said, who has the real power in a parliamentary democracy? Prime Minister and his Council of Ministers. Then why do we have the President of India? Just for continuity. Somebody has to be the head of the state, just like they have in England, for continuity. But if this individual does not have the real power, if we elect this individual directly, Prime Minister is also elected by the people, tomorrow they will have a clash. Prime Minister will say, I have an advice, please impose national emergency. President will say, no, why? I will not impose. Said, why? I am elected by the people. She would say, so am I. You're also elected by the people. I'm also elected by the people. So why should I listen to you? You listen to me. Don't impose national emergency. So to prevent that clash between an elected prime minister and an elected president, if both are directly elected by the people, that's why we resorted to indirect election. That was reason number one. Reason number two, members of the Constituent Assembly said it's a waste of time. It's a waste of resources as well. Waste of time. It will take a lot of time for all the people to come together and cast their vote, just like Lok Sabha election is conducted in 9 phases. There are 9 phases to elections. Even legislative assembly elections is conducted in multiple phases. Imagine now we have to elect the president as well. It will also be conducted in multiple phases. It's a waste of time because she does not have the real power. It's a waste of resources as well. Again, we have to organize elections. Again, we have to spend thousands of crores on elections if all the people of this country will be asked to vote to elect the president of India. So wastage of time, wastage of resources. To elect somebody who does not have the real power. To elect somebody who's only a nominal head. To elect somebody who's only a titular head. To elect somebody who is bound by the aid and advice of the Prime Minister and his Council of Ministers. It is for these reasons that the Constituent Assembly settled for an indirect election, which means the President of India is elected by the people, but not directly. Then indirectly. Indirectly through whom? Through the members of the Electoral College. What is an Electoral College? A body which has the right to vote to elect the President of India. Who is this Electoral College? For example, can you tell me what is the Electoral College to elect the MP of Lok Sabha? Let's say, what is the Electoral College to elect an MP of Lok Sabha from Varanasi? What is the Electoral College there? Not people of Varanasi. Those who are above the age of 18 in Varanasi, they have the right to vote. They are part of Electoral College. Clear? Then who is part of the Electoral College to elect the President of India? Electoral College consists of members, elected members of Lok Sabha and Rajya Sabha, elected members of the state legislative assemblies, including Delhi and Puducherry. And what is this Electoral College? We will discuss tomorrow. It's 9:30. We'll start with the Electoral College. Then we will jump to proportional representation system. Then what is the single transferable vote? Then what is secret ballot? Then what are the disputes related to the election of the president? Then we will discuss what are the powers available with the president. Then we will look at the Prime Minister, Vice President, Council of Ministers, Attorney General for India. And hopefully tomorrow we will have a good understanding of the Union Executive. Okay? Please take my question. But sir, you said rigidity means joint action of both center and the state, but it will not include special majority used by parliament to amend the constitution. Rigidity has multiple meanings. One, rigidity means constitutionally that if constitution is to be changed, it should be the joint act of both center as well as states. Both of them should come together to change the constitution. Rigidity also means that it is difficult to change the constitution. When we look at the Indian constitution, what is it? C. Oliver De Fusaro. They say Indian constitution reflects, or the amendment process of Indian constitution reflects flexible rigidity. That means in some cases it is very flexible. Flexible in the sense, easily we can change the constitution through simple majority. In some cases, it is rigid. Rigid in the sense, unless and until both center as well as states, they come together to change the federal features of the constitution, these features cannot be changed. So it is rigid. So the mix between flexibility and rigidity, that is why they called it flexible rigidity. Is that clear? Sir, how to wake up early? Set an alarm and wake up. Okay, done? But it will not include special majority used by parliament to amend the constitution. Why it will not include? It will include. Because when you use special majority, that means it's slightly difficult now to change the constitution because you require majority members to also get involved and accept it. That means this process is rigid, very difficult to achieve. Sir, how do you come so early to teach in the morning? I drive and come. What sort of questions are these? Very good questions, but this is just to add humor as well. Okay. Sir, can Article 52 be amended? That is, can we say tomorrow that there will be a president, or is it part of the basic structure? Are you saying that there will not be a president? Yes, it can happen. It can happen. As of now, it's not part of the basic structure. But tomorrow, the judiciary can say this is also part of the basic structure. Okay, today's class was amazing. That I know. See you tomorrow again, 6 o'clock in the morning, and we will discuss even more fascinating aspects related to Union Executive. Till then, stay safe, stay happy. Bye bye.